And that translates in US dollars to trillions and trillions of dollars lost to corruption. And every country that loses money to corruption, that's taking money from its taxpayers, its shareholders. So there are some very strong implications for why this issue is so important. And we're going to start today by talking about SLAPP suits. We introduced the concept yesterday, strategic litigation against public participation. And it's those last two words, public participation, that are so important, because every citizen, every person, every human being has a right to be heard. Simple. And when you're speaking out for the greater good, you shouldn't have to endure personal harm. So as we continue this conference today, and we start to think about what we're going to talk about for the rest of the day, I just want to quickly review that yesterday we talked a lot about the individual impacts. We talked about trauma. We talked about suicide prevention. We talked about families. We had a special panel from another country, from South Africa. People came via the Zoom to talk about their experiences, the killing of whistleblowers. We remember Babita Decoran, John Barnett. We've talked about whistleblowers who have passed because they pass us the torch. And we must continue this quest because it is so important for each and every one of us. We're talking a lot about corruption and money, but it is also the water we drink must be clean. The air we breathe must be pure. The children we raise as a community must be safe. So I start the second day, and we're going to talk about SLAPP suits again and how the whistleblowers and journalists come together on this issue. And then we're going to talk about diversity and inclusion in the workplace, like what makes the workplace safe. And then we'll have some very specific panels about the cases that are here in Greece. We'll talk about rewarding and rehabilitating and compensating whistleblowers. I mean, that's one of my favorite subjects, is on turning hostile work environments and disability and looking at how those things impact each other. And we'll talk about the global perspective, and we'll come full circle on how are we addressing this global problem that harms every citizen in every country and every corner of the world. We are touched by this because when there is corruption, it's not just the whistleblower that's harmed, it's everybody the whistleblower is trying to protect. So without much further ado, I'm going to introduce the first panel, Advocacy and SLAPP, Protecting Journalists and Whistleblowers. And we're going to bring back Nicholas Leondopoulos, who did a great job talking about SLAPPs. I'm going to ask him to recap a little bit about what he talked about yesterday. We had so many comments about his presentation yesterday and what a great job he did. So welcome our first moderator of the second day.
So good morning to everyone. I'm Nicholas. Yesterday we had, I think, a very interesting first introduction into the problem of SLAPPs. But I think that what is going to follow up is going to be a fascinating discussion, even better than the one we had yesterday, because we will try to go really deep into the issue. We have three very interesting speakers. 3 or 4, actually, no, 4 very interesting speakers. Or I should say fascinating speakers, and you will understand why. So the title of the session is Advocacy and SLAPP, Protecting Journalists and Whistleblowers. I will present the 4 speakers, say just a couple of words for each one of them, and then they will start talking, and we will have an exchange with some questions, etc. So first of all, it's going to be Philip Wissing, who is a Blueprint for Free Speech's coordinator for the new German National No SLAPP Coalition and Campaign. Then I will give the floor to Fotis Giannoulas, who is a Greek lawyer, a member of the Athens Bar Association, and a managing partner at Giannoulas and Associates law firm in Greece. Then it will be the turn for Thanasis Koukakis, a fellow journalist who, during the huge Greek Watergate scandal, also became a friend of mine, and I have deep admiration for him because not only he was the first you have to know about Thanasis Koukakis. He was the first European citizen that it was proven, we have evidence, that he was targeted with the illegal predator spyware in Europe. And Thanasis is important in many ways. He was a reporter. He was a source for much of the reporting on the Greek surveillance scandal for the journalists that reported on that. And he's also a victim, because not just that he was a victim of surveillance, but he was also dragged into courts. He's the victim of SLAPP lawsuits, actually not even for publishing a story, but for retweeting stories that some of his colleagues wrote about the surveillance scandal. And last but not least, it will be Janine Louloudi, my colleague from Reporters United. I won't say much about what she will say, because for me it's very good news that she will present something that happens for the first time in Greece, and I'm very happy that I will be here while she's presenting that, because this is the moment we have been expecting for 4 years. So let's start with Philip Wissing, that will make his intervention online.
Thank you very much. I hope you can hear me well. It's a great honor and privilege to speak here. And thank you also for the very kind words, Nicholas. I hope I can be as fascinating as announced, but I'll do my best. But indeed, it's not about us primarily, but it's about those who are affected by legal intimidation. That's the topic of today. And as you already introduced me, Nicholas, I'm working for Blueprint for Free Speech currently on a project in Germany. We are establishing the first no SLAPP contact point. So the first opportunity for those affected by SLAPP, and also for the broader public who are interested in that topic or who actually want to learn what SLAPP is, to find a place to speak to contact, to get legal help, which is nothing that we can guarantee, unfortunately, but we can help to find lawyers who are willing to support. And firstly, and then foremostly, we really want to raise awareness for this topic, which has been coming more and more all over Europe, also in Germany. And that civil society has seen a rise in SLAPPs, and it's really important that we talk about that. So in Germany, we always have this attitude, or many people have this attitude a lot of times, that it's different than anywhere else in the EU, particularly when it comes to the legal system. Many people think that in Germany all is different, all is better, particularly when it comes to SLAPP. There is this, I'd even say, arrogance sometimes of people saying, yeah, that's a problem of other European countries, which is a big mistake, because, I mean, first of all, Germany is also part of Europe, so if it's a European problem, it is also a German problem. People should not forget that. But then, again, we have SLAPP cases in Germany too. We know that this kind of legal intimidation and abuse can happen everywhere where a legal system is in place, which allows people with more resources than others to use and misuse the legal steps which are there to legitimately claim, for example, questions of personal representation in the public, to misuse these legitimate steps to intimidate. So we know that this is possible. Of course, it's also possible in Germany. And in my opinion, one should not focus too much on numbers when starting to dig into this phenomenon, because once we know that it's structurally possible, and once we've seen cases, and we see cases in Germany, I can say something about that shortly, it must be the priority to get to those who are affected by SLAPs, to make them good offers to actually talk about their cases, because that's how SLAP work. If they are effective, they will get not known. They will be out of the public. We heard it in the introduction. It's about public participation. And if there is a mechanism in place to effectively bully and intimidate people out of the public sphere, then it's absurd to ask for numbers, because if this mechanism really works, then there are not many numbers because people get silenced. So that's our starting point. We know that there's a problem. We're also part of the case of the coalition against SLAPs in Europe, and of the local German coalition against SLAPs, which is really important to be there for those affected by SLAPs, to organize themselves, which is really important. I think it's a lot about community resilience, organizing itself. And out of this coalition, we started our current project, which got state funding, fortunately. And it's a powerful partnership of 6 NGOs, organizations. It's Blueprint for Free Speech, the organization I work for in this project. Sulet has been here yesterday, I think, and talked already about SLAP. Blueprint is involved in many free speech and whistleblowing issues around the world and projects, and trying to help those affected by strategies of intimidation. And then we have Reporters Without Borders in Germany. We have the German Journalist Union, the German Journalist Association, the Transparency Organization Ask the State, and the Action Against Labor Injustice. So that's the project network. And we are hoping, we only officially launched in May last month, so it's quite new, quite exciting, everything. We're hoping to provide a good offer for those affected by SLAP. We are hoping also to count more cases, definitely, to get more numbers in the course of our project. But we want to combine this with effective help. We don't want only to count the sheeps and then people are affected and get counted, and it doesn't help them immediately, but we want to turn it around. We want to establish an offer they can take advantage from in the very situation of being affected. And then we will document all of the cases that we come across. So that's maybe the introduction to the project I'm in. I can get deeper into cases that are in our heads, also into the services we offer. But maybe, Nicholas, do you have any questions, or do you have any intermediate comments?
Are there any questions or comments for Mr. Wissing? I wanted to ask you a question, because this is something we get a lot when, I'm a reporter, I'm a journalist, and our project has been a victim of gigantic slaps in Greece. Actually, we are now dragged into courts for 2 defamation lawsuits for over 3.5 million euros, when our annual budget is around 150,000 euros. But one question that we get a lot from, let's say, ordinary people that are not so much into slaps is, to play a little bit devil's advocate, isn't it the right of a person who is, we report about a person, isn't it their right to sue us? Don't they have the right to go to courts and defend their personality? So why should we have a special legislation about slaps? And what would be the characteristic that differentiates between a normal defamation lawsuit that should go to courts and a slap?
Yeah, good question. I think it gets at the heart of the directive also, and of all of the measures in place to prevent slaps from a legislative point of view. I think, and that's part of one of the problems at first, that of course you can only be sure if a claim that was brought to court was abusive, was unfounded, manifestly unfounded, after the court has spoken the judgment, right? And then you also have to rely on the judges to make a proper judgment. So I think that's two restrictions that are there for a proper judgment, whether something is a slap 100%. But I think it is about a strategical dimension a lot, because I don't know how you experience this in your case, but we see many cases where we assume, or where we have strong indices to think that companies have their strategies, their legal strategies, and where they strategically know that they can. I mean, because for them it also costs money, right? To go to court and to claim defamatory or defamations, and they have to hire their legal team. They have to make the court case too for several months, but they have this calculation. Okay, this will cost us this amount of money, but we think that it will help us to get this opponent or this critical voice out of the public, and we will be at peace. And so it's worth for us to spend $400,000 over the next 2 years. And this strategical dimension and perspective will be different if they know that there's a risk, and a quite big risk, that if in the end, after the process is over and after there's a judgment, that then someone will make the claim of this was a slap. And if then we have, and we hope that we will have, strong legislation in place which has, for example, recompensation claims if it really was a slap, so that it's not only that the slapper has to pay for all of the costs of the trial, but also to pay more. And if there's a real risk by that, then we hope, or I think it's a realistic prospect, that big companies, wealthy individuals will not use this so strategically anymore, because they can't just rely on, okay, we have a couple of lawyers, we have money, we can just go for it, and let's see how we can make the life of this journalist as hard as possible. But they will also need to take into account that they will maybe have a problem after the lawsuit, that they then will get the claim of slap. This is a really abstract strategic level. I think it will still change something, but of course, I think that's the second answer to this question. It's important to provide more help to those affected by slap than this very vague, well, in the future, if the trial is over, you can claim that it was a slap, and then you will have to have another trial maybe, and it will take even longer. So this can't be all, and this is where we focus a lot also on help that doesn't only focus on this label slap, which gets officially, which you can officially call once the trial is over. But we think that in the moment where public voices feel intimidated or get intimidated, they should get help, they should get community help, they should get legal help. And I mean, I think that's something that civil society needs to organize, and that's more than any legislation will probably come up with.
And any other question? Please, yes.
So can you tell us about the other 6 NGOs that are involved, and how can more NGOs get involved in this anti-SLAPP effort, or at least once somebody has been slapped, what kind of help and support can we offer?
So I only understood the end of the question, but I can definitely say something about how NGOs or others can get involved. And if there was more to it, then just let me know.
Well, I was asking who the other 6 were. You mentioned that there were 6 NGOs.
Yes.
Who's also involved in this effort? So in case we want to reach out, we know blueprint for free speech, but who are the other 5, and how can we get more involved with them?
Yeah. So the other 5 are Reporters Without Borders in Germany. Then there is the German Journalist Union in Verdi, one of the big German unions. Then there's the German Journalist Association. And there's a transparency organization called Frag den Staat, Ask the State. And then there's Action Against Labor Injustice, who focus on union busting and general questions of the public, which is constituted at work. You will find the partners also on our website, noslap.de, and there in the About section there are all the partners listed, also with link to the websites. And it's and this is a selection, I would say, of organizations who are active in the No Slap coalition in Germany. So there's at first this coalition, and I think that's an approach that I would always recommend, that it's important to at first have a level of activism, of getting active, of getting organized, of individuals, organizations affected by SLAP or willing to support those who are affected. Because much of the work at the beginning is campaigning, raising awareness in an activist way, getting involved in court cases that are ongoing, right? Gathering money, crowdfunding, etc., which are things that are difficult for, or at least in Germany, for state-funded or other funded project. Depends on the funding, of course. But so this is why I would always recommend to first have a activist coalition, because I think it has, or I'm sure it has a political dimension. It's about recognition, right? We still have this discussion here in Germany where many actors, political actors, legal actors, lawyers, say that there is no problem, that this is absurd, that doesn't make sense, because, as Nicolas said, everyone has the right to go to court, and why making this a problem? So I think there is a lot of advocacy work need to be done everywhere, and also in the specific cases, because it is about motivating those who are affected by intimidation, by acts of frightening people so that they don't speak in the public, to motivate them to speak in the public. And I think there's always needs, at least that's what I hear from those affected, that it always needs the feeling of others fighting for a cause, and that needs more than just, well, I can write a piece here and that's it, and but rather, okay, there's someone attacked and needs to go to court, faces really big sums of money, maybe jail time, which is not really probable to happen if the courts are not corrupt and if the case is well founded. But still, it's intimidating by itself. So yeah, I think this coalition work is important, and then, of course, the second step would be to look out for funding. In Germany, we had this state funding we could apply for, and we got it, fortunately. There are many other funders, of course, but then I would say it's important to form out of these coalitions smaller groups who focus then on really technical aspects, and that's the second thing that we do. So technical aspects, we offer training sessions so people can invite some of our experts and get training to prevent threat cases by doing really good research, by not exposing themselves by any small mistakes. And then we build a big network of lawyers and legal experts. And then we are present at many other events. We're developing a guidebook, and we have a regular call where people can talk to us. So that's a rather technical side, I'd say, which is the second dimension that I would always recommend to go into.
Thank you very much. Any other question, or should we move on? Okay,
just
Ari.
a quick one. Hi, Philip. This is Ari from Liberty of Speech. Is it my understanding that on the directive there is a clause that protects organizations that deal with whistleblowers, and due to their professional, for the jobs, put it this way, they can get slapped And if that happens, they are protected by the directive. And can I assume that journalists who are using sources and they can suffer retaliation due to slap suits can also be protected by the directive? That is my understanding. Correct?
Yeah. So I'm not a legal expert on these questions, but my understanding is the same. And I think that every one of us journalists, whistleblowers, should really try to use these legislative tools to push for interpretations of the directives that allow as much protection as possible. So if you can rely on this in your daily work, I would ask your lawyer to be sure. From an advocacy point of view, or if you want to talk about it in public, I would definitely call for this to be true. I would definitely insist that this protection should be there.
Thank you. And may I add to that the actually burden is on the slapper to prove that his case, his lawsuit, it's not a slap suit. So that's a great tool on the directive that we can use as journalists.
No, I definitely agree that we should all, get more into this directive, get to know it better, and then really try to use it as much as possible. Thank you.
Thank you very much, Mr. Wissing. I saw Mr. Giannoulas nodding on this last point by Aris, so it's the right moment for him to weigh in the argument. This is Fotis Giannoulas. He's a lawyer, he's a member of the Athens Bar Association, and he's a managing partner at Giannoulas and Associates in Athens, Greece. And my very basic question to you, Mr. Giannoulas, would be to explain to us the legal status of the anti-slap protection in Greece, if there is any.
Thank you very much. Good morning, everyone. Let me start by introducing myself. My name is Fotis Giannoulas. I'm a lawyer since 2003, founder and managing partner of Giannoulas and Associates law firm based in Athens. I am also a member of the board of directors of Athens Bar Association since 2022, and I'm also honored to participate in the working group for the reform of the Greek Code of Civil Procedure, recently established in the Ministry of Justice. My approach to slap suits will be more technical legal. I will try to speak as clearly as possible, being fully aware that most of you are not lawyers. Let's start with the definition. What makes a slap suit be a slap suit? Slap is manifestly unfounded or abusive court proceedings brought against natural and legal persons on account of their engagement in public participation. And when we talk about public participation, we refer to any statement or activity by a natural or legal person expressed or carried out in the exercise of the right to freedom of expression and information, freedom of the arts and sciences, or freedom of assembly and association, and any preparatory, supporting, or assisting action directly linked thereto on a matter of public interest. To put it in a nutshell, a slap suit is a lawsuit that, regardless of being partially well-founded, has as its main purpose to silence the opposing party, to prevent him from taking action primarily through his freedom of expression, by which he attempts to raise and serve a matter of public interest related to the exercise on constitutionally protected rights of members of society. In order to describe a lawsuit as a slap suit, we will usually see a claimant forum shopping, filing a lawsuit and successively waiving and resubmitting its lawsuit, seeking extremely large sums of money as damages, pursuing various claims in multiple pleadings. Purely procedural behavior may also be accompanied by practices of intimidation, harassment, or threats before or during the proceedings. Slap suits are not new. They belong to the category of abusive lawsuits. It is lawsuits whose purpose is not really to protect the claims that are theoretically pursued by them, but to intimidate the opposing party or even to send a different message to third parties. The last category is the oldest. It is the most numerous, and this is the reason why SLAPP suits can easily be concealed in the multitude of such suits, particularly in relation to the Greek legal community, which is most unfamiliar with SLAPP suits. Indeed, it is very common in Greek judicial practice that whenever an allegation is made, even in the context of a court proceeding, that could be inaccurate and cause some damage to the image of the person to whom the allegation relates, that person files a lawsuit or even submits a criminal complaint in order to indicate in a significant and forceful manner that the allegation is inaccurate. The same applies not only to inaccurate allegations, but also more generally to expressions of criticism expressed in characterizations. And the slightest potential breach of a threshold usually leads to counterclaim or even a criminal complaint. In all this multitude of such suits, we have to distinguish between those which are simply abusive suits or suits brought in excess of a reasonable standard, and those ones we are interested in here, the SLAPP suits. Only a small part of this large number are indeed SLAPP suits. The special issues involved in SLAPP suits were first highlighted in the USA in the 1960s, and subsequently the issue became a matter of concern to the European legal orders. The European Union has already resulted in 2 legal texts that set out guidance for the legal orders of the member states of the Union, a directive and a recommendation from the Commission. We will come back to this in a moment, but before we do that, it is worth asking ourselves, does the Greek legal order lack the instruments to deal with such lawsuits? And does it need to add legal instruments? The answer is both yes and no. Our national law has instruments to deal with such lawsuits. First of all, SLAPP suit is a type of abusive lawsuit, which is forbidden under Article 281 of the Greek Civil Code. The reason why the courts of our country do not have a specific approach to such lawsuits at the moment is not the lack of legal instruments, but the lack of an appropriate mentality in the legal community, and especially among Greek judges. It is the same mentality that has led our country to a very poor performance in relation to the protection by the Greek courts of freedom of speech in general. There is no culture of protecting freedom of speech in Greek courts. Greek judges do not seem to see themselves as potential protectors of freedom of expression. It seems that they see themselves as protectors of individuals from the excesses of free speech, rather than the other way around. This probably has to do, perhaps, with the reduced credibility of journalists and the way journalism is practiced in our country. Those present are accepted, of course. For this reason, we can find great strictness in judicial judgments regarding the limits of freedom of speech, with the result that even value judgments that deviate from absolute decency are punished with relative ease. It is worth pointing out that the issue of SLAPP suits is not limited to freedom of expression cases. However, freedom of expression is the basic means by which public participation can take place. It is the raising of an issue of public interest that concerns society as a whole. The national instruments therefore exist, and if the courts want to discourage SLAPP suits, this would be possible, although it is possible that these instruments would be inadequate or not as effective as would be desirable. The legal instruments introduced or proposed by the new legal text of the European Union can make us realize that the existing instruments need to be strengthened and enriched. So let's look at these legal texts. The European Commission has issued a recommendation to Member States to adapt their international legislation by proposing specific tools since 2022. The same tools have been included in the directive published some time ago in 2024. The recommendation of the European Commission is not binding in the Member States and contains proposals for the adoption of national legislation for cases of a national, domestic nature, while the directive is binding on the Member States, contains specific provisions that the Member States are obliged to incorporate by 2026, and concerns cases of a cross-border nature. It would, however, be significantly contradictory for a Member State to have special rules for SLAPP suits where there is a cross-border character, and for such special rules not to apply where the parties are domiciled in the same country. The main provision proposed or introduced by the recommendation in the directive are the following. First, to provide for the award of costs or the possibility of awarding damages to claimant bringing a SLAPP suit. This point is particularly meaningful if this can be done even in the event of a partial success of the action, because in the event of defeat, the costs are in any event to be awarded to the unsuccessful party. In any case, the imposition of court costs, even on the successful party, if it is charged with abusive conduct, is already protected for in Article 185 of the Code of Civil Procedure, while Article 205 of the same code also provides for the possibility of imposing a financial penalty against a party who engages in conduct. The second legal instrument, in particular, is very rarely used. The possibility of awarding damages to the defendant in a SLAPP suit still exists today through the possibility of filing a counterclaim, alleging that the filing of the suit itself constitutes abusive and therefore tortious conduct, although this is quite rare in practice. Second, national legislation shall provide for security for the claimant in a SLAPP suit, i.e. a sum of money corresponding to the legal costs and any compensation of the defendant in case it is actually proven that a SLAPP suit is involved. A guarantee mechanism for court costs is already provided for in the current Code of Civil Procedure, but its use in practice is very rare. I personally have never seen a security for court costs. Third, national legislation shall provide for the possibility to dismiss with SLAPP characteristics, dismiss a claim with SLAPP characteristics at an early stage, i.e. before the substantive examination of the case. The decision at this early stage must be final, in particular if it leads to a dismissal of the claim described as a SLAPP. And national legislation shall provide for the possibility to appeals against it. The purpose is obviously to ensure that the very existence of the lis pendens ceases to be a cause of fear for the defendant party. It should be noted, however, that the judgment as to whether or not a suit is a SLAPP suit is not a simple judgment that can be made roughly and instantly. There is therefore a risk that we could end up with a two-stage trial, both of which could last for a considerable period of time, with all the financial and psychological damage that this entails, particularly for the defendant. A mechanism for a general early examination of a lawsuit is currently not provided for in our civil procedure, but in the context of the discussion of the revision of the Code of Civil Procedure, the general provision of such a stage in civil proceedings is indeed being considered. Fourth, the directive suggests the adoption of a specific public policy clause for the enforcement in a member state of a judgment of third country, which is considered that is connected to a SLAPP suit in a member state, i.e. the possibility for the courts of that country to refuse enforcement of the judgment in the member state. The directive also makes it possible that, for a national court of an EU member state to award compensation for costs and expenses incurred in proceedings in a third country, in derogation from the general rule that costs and expenses are awarded by the court seized of the case. It is the time, therefore, for the Greek legal order to adapt to these requirements. For the directive, in theory, it still has 2 years to do so. What is certain is that the very adoption of the recommendation and the directive have the power to shape judicial judgments even before the adoption of specific domestic rules. Personally, I'm not so concerned about incorporation as such. I'm more concerned about the change in the mindset of judges, who need to see themselves more as protectors of free speech and become much more sensitive to how they react to abusive litigation and especially slap suits. If this is not done, no matter how many legislative changes are made, they will hardly be implemented, just like the tools that exist today anyway and are not implemented. Consequently, the issue is the change in the mindset of the legal community and familiarization with the issue of slap suits, to understand that this is a separate and distinct behavior, to understand the value and the need to address it. And in this direction, today's event is particularly useful and important. Thank you for your attention.
Are there any questions for Mr. Giannoulas?
Mr. Koukakis.
You said that the new directive provides that the cases that are abusive must be dismissed in early stages. Is there the proper framework in Greece in order this provision to be facilitated or not?
As I said, at this stage, we have not a mechanism of early examination after issuing a lawsuit, filing a lawsuit. In the committee, in the working group, we are checking if a stage like this could be in the reform of the Code of Civil Procedure. My thought is that this stage could examine some basic things, and the thing if a lawsuit is a slap suit or not is a very complicated issue, and as I said before, I'm not sure that the legal community in our country can deal with a so complicated stage before the main stage of the trial. That is my thoughts about it. We have to make an effort to see. We are obliged to do it from the directive, to see how these two systems can be complied the one with another.
Any other questions from the audience?
Hi. So my question is about Greece. They're saying justice delayed is justice denied. Now, with your experience, what is the average execution of a court case from start to finished?
Generally, or in these...
well, it's a civil matter. Slap suits will be civil matters, correct?
Today, if we file a lawsuit for which could probably a slap suit, we had the trial about December 2025. It is not very far. Most of the cases have a trial date 2 years or 3 years. I think that if I file a suit today, I could have the possibility to execute it in about 4 years. About.
That's which executed means the court trial.
No. Execute, I mean that I could take measures in order to have not the trial. The trial is going to be done in about 1.5 year from now, in a potentially slap suit. But in order to have the right to have the money of the judgment, I think that I need about 4 years.
Okay, and that will be the first instance court. Don't you have appeal afterwards?
4 years, I think. I mean, after the Court of Appeal.
After 4 years.
After the Court of Appeal.
And that is what our concern is, that how does a person survive those 4 years?
I understand it. Yeah. Generally, I think that the delay in justice is not only a Greek problem, is a problem in all the West, I think, not in the same way in all the countries. Here, in some proceedings, things are very bad. We're trying to figure out new ways of reducing this time. It is not a simple problem. Now in the working group in the Ministry of Justice, we're trying to find ways not to have unjustified delays. I think that things in a couple of years is going to be better, not significantly better situation.
I think I recall last year, and I'm speaking the correction, that there was an issue with delayed cases, and there was a judge that was dismissed because
Yes,
they found,
not only one.
they found court cases lying at your place that they wouldn't have proceed.
Yes.
And we have a judgment against Greece, I think, from
Not
the
only
EU
one. Not only one.
for delaying court cases.
Not only one. The Court of Human Rights in Strasbourg is very strict with us, and that is its duty. We have not good records in the time of having a decision. I think that the changes we are talking about are going to make some progress, but I don't think that we are going to see miracles.
Thank you so much.
I would like to, first of all, are there any other questions from the audience? Okay, very good.
A lot of cases in the United States are done through mediation. Are there
Mediation, yes.
mediation or arbitration that speed up that judgment process? Does Greece have that same opportunity?
Since 2019, we have a new law about mediation. But the way until now it is implemented is, I think that the results are not very satisfying. We have a procedure before a hearing that we have to have a conversation with the other party to be informed that we have the possibility for a mediation. But this hasn't caused a significantly raise of the number of cases which are resolved in this way with mediation. We have to make more efforts about it, but I think it's, one more time, a matter of mentality. But we have to see not only procedural ways to increase the number of cases to be resolved by a mediation. In this working group, we're trying to figure out what could do to change the situation.
Thank you.
I would like to add a couple of brief comments which could also act as a question. The first one is a little bit inappropriate in the sense that we are talking about the huge problem in Greece of justice system being extremely slow, but I would like to add that sometimes it can really speed up things. And,
Yes, of
and
course.
this raises questions. For example, in our defamation case, we published the article in August 2022, and we got our first trial date 3 months later. Very fast, very fast. The person that sued us was at that point the General Secretary of the Prime Minister, etc., etc.
I know.
I'm making the comment because now we are almost 2.5 years, almost 2 years after this lawsuit, and still in this surveillance scandal, the people that were involved have not even been summoned as witnesses. So the journalists were brought in court, were tried again and again and again for a defamation lawsuit that, according to international press freedom organizations, is a typical slap. But at the same time, the people involved in the scandal have not even been summoned by the judicial system as witnesses. So there is this peculiar asymmetry when it comes to the pace of the justice system.
I understand. I agree with your remarks, but we have to point out that these are two different parts of the judicial system. Is the penal part and the civil part. They are not connected in a very tight way.
And although we are a little bit delayed, but I just wanted to add one thing in a little egoistic way because it concerns the journalistic community. One of the abusive practices, in my view, is that we've reached this point when even before you publish your story, just because you file questions to the person involved in the story, you get slapped. And actually, I go back to what you said about the mindset being about protectors of freedom of speech, that in this case, the speech has not even been spoken. The information is not even out there in the public domain. And
I understand.
the other person, it can be an entity, it can be a company, it can be a politician, it can be a business person, is attacking with a slap just before you filed a question. And I would just want to ask you if you think this could be considered as an abusive practice.
It is an abusive practice, but beyond slap suits, there are many other cases that we have also have under consideration. For example, I publish an article that says that I am a rapist, that somebody is a rapist. It is very hard for that person to be innocent. Even 10 of decisions are say the opposite. So we have to see a balance. The power of press is very big. Not only press in the traditional way of Facebook and all the social network. We have to find a difficult balance, and that's because I'm very skeptical about characterizing a lawsuit as a slap suit. Is a very difficult decision, and it is very difficult to see it in a very in early stage, as the directive says. It is something we have to take into consideration.
Okay, thank you very much. So I would now ask Mr. Koukakis. So Thanasis Koukakis, as I said before, we stay here. You prefer to go there or to stay? No, that's okay. He prefers the desk.
In order to have a more vivid interaction.
So a small just presentation about Mr. Koukakis. As I said before, he is everything. He's a reporter. Something that people do not know, that he has been also a source for much of the reporting in the surveillance scandal. The outlets, including us, that reported on the surveillance scandal were in many cases based on information or in previous research that Thanasis has done, and this is very important to give him the credit for it. And finally, he has been a double victim, a victim of surveillance, of predator, and at the same time, a victim of abusive lawsuits, as we said.
I would like to thank the organizers for having me here. I will not speak about surveillance scandal at all. I will try to stick on the topic of our agenda, and I would like to highlight something that is very important and that had been too highlighted about the journalist sources. We are talking about the whistleblowers, okay, and how all the slap pressure interacts to them too. Okay, so slaps, it's not something aggressive, abusive that have to do with our job, with journalists, in order to stop us from revealing things, wrongdoings. It is very relevant with our sources. So imagine when slap has to do with reducing my credibility and reputation as a journalist, when slap have to do with delay or prevent the information that have to be published, or when slap, something which is very common, aiming to cause a self-censorship, okay, because I will be afraid, so I will not be eager to reveal the things that I already know. So those things, in an indirect way, had an impact to my sources too, okay? Because when a person trusts you something very sensitive in order to publish that, and you are not publishing that, at the same time he finds himself to be in a very fragile situation, okay? He is totally insecure. He did not know whether you utilized his information. Are you doing that for your own good, for your personal sake? No. Or are you trustworthy? Are you going to betray him? Okay, so there are many things that have to do with our sources and the whistleblowers. When you're reporting in a very high level, and you have to, and because of your position, you're a well-known journalist, okay? You're working for a very famous, well-known media abroad. I have to collaborate with CNBC, with Financial Times, Al Jazeera, and always in a very difficult stories. The people that were my sources have this perception that they will always be secured. So, and their first security is their truth to be published. The things I have given to you to become a public knowledge. So when this is happening, there is a salvation for them, because there is a fulfillment of the things that they have already given to us, trusted to us, okay? So through slaps, the people that they target journalists with slaps, one of their aims is to send a message to the sources of the journalists, okay? And in order to correlate it with the surveillance scandal, it wasn't the journalists the target, it was the people that were talking with the journalists, okay? So the deep state wanted to know who are my sources, and who are the people that I'm speaking with, who are the ones that making, leaks. So through slaps,
as Nicholas told you, I was not directly, I was not author of one of the stories that have been already been published about the surveillance scandal. But despite that, I have been slapped with 3 different lawsuits for retweeting the stories, the initial stories. So imagine, is this abusive? Of course it is. Okay. In the Twitter sphere, it was approximately 30,000 people that had made the same thing that have already made. Okay, they were tweeting the story. But why this specific person decided to file a lawsuit against me for just retweeting the story? So this was the reason that I asked Mr. Giannoulas about the early stages judgment about the SLAPP lawsuits, because if we implement the anti-SLAPP directive, something that we have to do until the 7th of May of 2026, that will be, a relief, because the judgment of the Greek judicial will be that this is abusive and have to be dropped off in early stage. So I have a personal interest by asking you. So I don't want to take more from your time, just to highlight this very sensitive aspect that SLAPPs are not targeting just journalists, they are targeting our sources too, because if they succeed to their goal in order to mute us, then the sources will be less eager in the future to provide them information, and by doing that, they have succeeded. There will not be any whistleblowers. There will not be any original sources, and they were going to have the full control of any situation. Okay, so if you have any questions, I will be eager to answer them.
Test? Okay. Thank you for this. It's actually an eye-opening to see the situation in Greece and what journalists go through when it comes to freedom of expression or speech. I keep saying that one of the journalists' mission is to amplify the voice of the whistleblowers. I come from a background of electronics, so I'm thinking electronics. So, you need a good amplification, a boombox, to amplify without distortion, though. So the truth has to come out. It's very important for the sources to be heard, especially when they feel like that they don't trust justice. So, and that is what we say, and under the European directive, we're saying external disclosure. That's what the directive allows us to have external disclosures. So, and essentially, I've read it's in black and white. It allows you to go via an external disclosure, even via a journalist, when he or she feels that there won't be any chance to be represented, by internal disclosure. That means going through the, judiciary process. So that's very important to understand. Now, on the other hand, balancing the story is also very important. Okay, I have personally been crucified by my previously disclosure in South Africa. So there has to be a balance, and there has to be two sides of the story. So there is a sacred relationship between journalists and whistleblowers, and there is you as journalists have a big burden, okay, and a duty to consider that amplification and what the impact it will have on the lives of whistleblowers. I don't know if you can understand what I'm saying, that you have to make sure that you don't want to just tell the story, okay, but you also want to make sure that you don't place those journalists under threat. I'm trying to understand, how is it possible to sue you because you retweet something? That's something I need to understand myself, and I think everybody here needs to understand that. I can retweet something.
Mr. Giannoulas, he's the one that he is. He had to answer that.
Want to?
It is a characteristic case of abusive behavior. I cannot understand what makes the retweet of Mr. Koukakis something more significant than my retweet for the same. It is not related. I cannot find something legally important in the behavior of Mr. Koukakis. Just for retweeting that. Just for retweeting.
Thank you.
Well, I can explain why he was a victim of this abuse. There was no legal reason whatsoever. It's very simple. He was a threat. He was seen as a threat, and this is why he was targeted. He's a dangerous guy. But I wanted to add, try to show how extended is the problem in Greece. Because Thanasis, it's very important that he made a big point about the protection of sources in Greece. So we have Thanasis Koukakis being surveyed by two systems, the legal AIP, National Security Agency system, and at the same time, and when I'm saying at the same time, I'm saying literally at the same time, from an illegal spyware that us journalists have connected to the Greek government. I'm not sure they cared so much about him, but I'm sure they cared about his sources. Then, Stavros Malichoudis, working for Solomon, doing story on migration. We know for a fact, because we've seen the report by AIP, that he was also surveyed, again, because of his sources. My colleague Tassos Teloglu, working for Inside Story, not on the surveillance scandal, while he was up in the mountain reporting on wildfires. Why would AIP survey Tassos Teloglu for the wildfires? Because he was talking to many different people. So again, it was about sources. My close colleague, Thodoris Chondrogianos, working for Reporters United, we do not have evidence, but we have strong indications because it comes from a very reliable source that while we were reporting on the surveillance scandal, the security authority, whatever, AIP again, tried to triangulate his position on the map to connect it to the sources to which he was speaking. So they were not surveying the content of what he was saying. Maybe they did that too. We do not know. But we know that while he was sitting in a cafe in a suburb of Athens, let's say in Glyfada, they were able to locate the people who were sitting at that cafe with him using a special application that creates a tree of his connections. So it's not about the journalist, it's about the sources. That's why it is so important.
Yes, in order to close that, public participation. Public participation is the one thing that can cause transformative impact. Okay, so this is the aim of the SLAP directive, is to protect and encourage public participation. And this is the message that I want to send, okay, that we are here to safeguard public participation. Okay, thank you.
Which leads us to the last speaker, probably the best one, I would say. Janine Luludi, my colleague from Reporters United. I think it's very relevant with how Thanasis closed his remarks, because this is well connected to the issue of protection of sources. I'll just say a small anecdote before Janine starts, because she's about to present us something for us has been very important over the last years. When we launched Reporters United as a small investigative network of investigative reporters in Greece, the first day that the homepage was on air, was online, it had a banner saying, there was a banner saying Greek Leaks, the first whistleblower for journalists in Greece, and then there was a small sign saying, coming up soon. So this website went online in November 2020, and everybody was asking us, how soon is this coming up soon? And we were saying it's a matter of a couple of weeks, maybe a month, and now it's 4 years after, and the coming up soon took us 4 years, but at least today the platform is live, and I suppose this will be one of the issues that Janine will talk about and present.
Hello. I'm sorry, you're going to have to bear with my voice because I'm a bit sick. I think I got a call to the Data Harvest Conference where we were 2 weeks ago, and everybody, part of the panels that were discussed there, it's a journalism conference, had to do with whistleblowers and slabs. So we talked a lot about the protection of source and slabs, and here at Reporters United, our team of journalists, both because of the nature of the stories we work on, which focus a lot on corruption, abuse of power, both in the public and private sector, and of course public interest, protecting our sources has been at the heart of what we do. So a while back we started an internal discussion on the need to give access to potential whistleblowers to our team, and in a way that would provide both anonymity and safety, but also a way that would be as inclusive as possible and would take into consideration, on one hand, the level of confidence that people, potential whistleblowers, have with technology, the type and volume of information that they would want to convey to our team, and also the nature of the persons or entities who would have an interest in preventing the information from becoming public. So possible adversaries and people who would try to stop the process of leaking information to journalists. This internal discussion, as Nicola said, took a while, but eventually it started bearing fruits. It evolved into a full-time project, which developed over the last 2 years, because there were a lot of technical difficulties to overcome and specific requirements that needed to be satisfied. But the result is finally here today on our online platform, Greek Leaks, and you can be the first to check it out. I think if you can show it. Yeah. It's here. You can visit it on reportersunited.gr/GreekLeaks. We will be doing a soft public launch on social media next Monday, June 17th. Before I say more about it, I will say that what is Greek Leaks? It's a platform that will allow citizens to send messages, information, and all kinds of material, documents, video, audio recordings, photos, etc., anonymously and securely to Reporters United. This can happen using 4 methods, and on our landing page we provide specific guidelines that need to be followed so that communication between whistleblowers and journalists remains anonymous and safe, and also some tips and things that we have carefully deliberated on and think will help towards that extent, towards that end. So the 4 communication methods are the traditional mail via post service to secure post office box, a dedicated number on the Signal phone app, GPG email, Proton Mail, and most importantly, the SecureDrop open source whistleblower submission system. SecureDrop is a system that was originally created by the Freedom of the Press Foundation, where, for anyone who's aware, Edward Snowden used to be president, right? And is a member of the board of directors. Through SecureDrop servers, anyone can securely send us encrypted messages, information, and files without the recipient knowing the identity of the server or details such as IP addresses or location. We will only know a date of submission and a code name of the potential server, but no other indication of who the whistleblower is. The communication happens over the Tor network, while for additional security, all submissions we receive are decrypted on an air-gapped device that is isolated from both the internet and our internal networks. Messages and attachments are all encrypted, and only accredited users of the system will have access to decryption keys. So it sounds a bit hard to use, but if you follow the guidelines, it's pretty easy, actually. Today, SecureDrop is used by some of the world's leading news organizations and investigative journalism platforms like the New York Times, The Guardian, Mediapart, ICIJ. And prior to Greek leaks, however, there was still no platform in Greece allowing whistleblowers to securely share information with journalists. So how did we do this? As Nicola said, it took a while. We wanted to create this platform and make it as open and accessible and transparent as possible for anyone, both to use but also to review the technology behind it and safeguard the privacy of the communication process with whistleblowers. To that extent, we collaborated with two main partners. In Greece, with the Open Technologies Alliance, ELAC, for all of you knowing ELAC. They helped us develop, they offered legal and technical advice, and they helped us develop, test, and evaluate the idea externally. And we also collaborated, especially on SecureDrop, but also on Signal, with the San Francisco-based Freedom of the Press Foundation. They have developed the protocol for SecureDrop, and FPF has reviewed carefully every step of the process. And we're happy to say that we finally got a green light 2 days ago to be included in the global directory of media organizations that have active SecureDrop instances. This will be jointly made public next week. And Greek Leaks, finally, is not just technical aspects, it's also what comes after receiving and decrypting information from whistleblowers who want to communicate with Reporters United. There are a lot of challenges there, both ethical, methodological, and we have thought of the position both the whistleblower finds themselves in when deciding to leak information, but also the trust that they put in us. So with our partners, we've discussed this thoroughly and have developed a protocol of careful steps and specific actions that we have to adhere to, especially the dedicated team members that will have access and manage Greek Leaks. And will then have the task of looking into the information provided. Reporters United is also committed to following the Perugia principles as a code of conduct for working with whistleblowers. And we understand that this will be a challenge from a journalistic aspect, but we are happy to take it on, I think, maybe. And hopefully ensure that information of public interest can make its way to the public without jeopardizing both the identity of the whistleblower and compromising the essence of the information they provide. So thank you.
No, and I apologize. I'm going to try to get us back on schedule a little bit. Our next panel should have started a little while ago, and I've got people online asking for where we're at. So I just want to bring us, and I know we promised the people here in the room a coffee break, but we also have the people watching on the live stream who are feeling very confused. So I will welcome you to go get coffee if you're here, and there are beautiful refreshments provided by our wonderful sponsors. So we want to enjoy them. So please go ahead and thank our sponsors for their efforts. But I think I'm going to move on because I see Dr. Jote Kokuria is on the line. Can we get her?
Yes, ma'am.
So can we bring up the next panel, please? That they're all.
Good afternoon.
I believe.
Good
I see.
afternoon, ma'am.
Yes. Okay, I can hear you. So let me just start by saying that one of the issues that we talk about a lot is workplace safety and how to build safe workplace cultures and have this diversity, equity, justice, inclusion in the workplace. And I've asked Dr. Jote Kakuria to join us because I know she's done a lot of research and work in India. We were also hoping that Georgina Halford Hall would be able to join us on this panel. Georgina, are you on the line? I'm not
Yes.
sure.
Yes, ma'am. Ma'am, I'm there.
Okay.
Uh,
Yeah, Jody, I think we have you.
Ma'am,
I don't know that we have the other panelist.
yes, ma'am. Ma'am, I'm there.
Okay, so I'm going to let Jyote go ahead and do her presentation, and then we'll take it from there.
Sure, ma'am. Yes.
5 minutes.
Afternoon, ma'am. Ma'am, if I could have the option of having my video on as well. I'll just present my slide once again. Ma'am, can I have my video on? I'm not able to put on my video.
Yeah, you can go ahead. I don't know if we can do
Yes, ma'am.
right now. He's working on getting both video and
Yes.
slide deck.
Right. I'll just take a moment to present my slide. All right, here we go. So first and foremost, thank you so much, Jacqueline ma'am, to have me here. This is one of the platforms that I had been awaiting for long to share my experiences and insights with you and with this everyone around. I'm going to quickly kickstart with justice, equity, and the courageous whistleblower, and the problem that people have when we talk about their social inclusion. So, talking about that justice here means not only the legal justice, but it's also the procedural justice, the distributive justice that we talk about. So, where we talk about that resources are inadequately and disproportionately distributed. That's exactly where the challenge is. And when we talk about anybody to be courageous, that's exactly where the courage is punished. The moment a whistleblower would like to voice out their concerns, there is a problem that they face, which is into inequality. That is, I would like to introduce the concept of workplace ostracism. The moment a person realizes and is decides to voice out that realization that something wrong is happening, that same moment there is an ostracization. So there is either ostracization in the form of avoidance into the similar group workplace. If we talk about knowledge hiding, yes, that's true. It's about the workplace deviant behavior, lack of organizational citizenship behavior that organizational members do not let them go through and be a part of the group. So I would like to share here one of the most significant concepts, and which is based on justice and equity, which are the fundamental pillars for any fair society. Yet in India, there are a lot of systemic issues and institutional biases that undermine these principles. So when we talk about the critical role of any whistleblower in exposing this injustice, they are driven by a lot of negativity, a lot of stress, and therefore they face a lot of personal risk, even to the extent that they receive calls of threat, not only from the people in their own fraternity, but otherwise as well. So when we talk about the legal protectors, it is something which is just mentioned into theory, but when we talk about the practice, the positive is far behind, and they're always chasing it. I, as a mental health advocate who really supports loads of whistleblowers around me, have found this significant study which has 241 citations, which came about almost 1.5 decades ago, which is about predicting the proactive behavior at workplace. Now, when we talk about any whistleblower at the workplace, somewhere the learning happens during the school days, college days, or any of their educational platforms. I would like to suggest that this study came up with this conclusion, this finding, and I would like to corroborate that personality is very significant, else reality is same for one and all. But how do we react in the form of high extroversion to talking about dominance, and that low agreeableness are all the antecedents of a personality wherein you can trait, you can conjecture that this particular personality is going to be a whistleblower. Now, having said that, I would also like to introduce the freedom of speech, the Article 19(1)(a) of the Constitution of India that says and guarantees freedom of speech and expression to all the citizens. Yet, there is a lot of challenge into the implementation and application of it. Now, when we talk about that everybody has that freedom of speech, the most difficult challenge for anybody around us loads of social threat. We fear that we are going to be out of society in case we do not talk something which is prevalent in the society. So the moment there is lack of social conformity, there are challenges of social exclusion. So this problem of having the equity, inclusion, justice are all names, are all words that we can find easy in the dictionary but never in reality. And that's exactly where all the whistleblowers are struggling. Now, with this, I would like to come up with the roadmap of my presentation, which is about I would like to introduce a very significant aspect that happens usually into the academic domain of the country, but is least voiced out, almost never published, never did it come into any of the social media platforms as well. Because again, when we talk about the social conformism of any student to the institution, there is again a gap that usually students keep to themselves, and therefore the quality does not enhance. So when we talk about their expectations of their development to talking about the institutional responsibility of their development, that challenge, that gap continues to prevail, and rather becomes, it has become perennial, and therefore there are a lot of challenges when the students face. So one of the challenges, the barrier to justice. So till date, we have this, and I just had one of the call for chapters as well, which is right there into US and other parts of the world as well. The moment we talk about skin color, so India is a country which is divided, it is united, but yes, it is extremely divided. So every state has a very different culture. When we talk about the skin color, not only the gender inequality I talk about or the gender discrimination that happens, even the skin color and the way you look is exactly where the opportunities come or do not come your way. The way you are treated by the society when we talk about any of the females to be dressed and decked up for the weddings, to talking about the similar psychology that has been prevailing since generations, this is actually where loads of problems happen into mentality, psychology, and which gets manifested into social reality when the similar people come together as workplace. So when they are going to work into a team format, there are loads of risk and repercussions that I would like to introduce. Further, I would also like to come up with, which is a very unique aspect to the entire conference, which is about how can we strategize for effective whistleblowing and advocacy. And I would like to conclude with loads of suggestions to the whistleblower that how can they softly and very politely and slightly indirectly put across their issues. Now, to begin with, I would like to talk about the culture of India, which is somewhere a very strong prohibiting factor for any of, so whether I talk about a male or a female, so there's a lot of let go culture that in case you feel bad, do not voice it out. Let it be. So if there is some part of the reality into someone else's psychology or perception, let that prevail. So if a male thinks that he is dominant over a female, that should continue to ensure social peace is maintained. So when we talk about the family peace to the workplace etiquette, everything guides towards that the culture of the country is that you should not voice out. Although I would like to refer back to the previous slide wherein we mentioned that freedom of speech into Constitution of India came way back in 1947, but today into 2024, the practical implementation is still missing. And my further slides are going to talk about a case of it and the solutions further. Not only that, the religious myths and the loads of religious scriptures that we've studied, the philosophy that we have inculcated into the country and which has passed down from few generations is exactly where the contextual influence shape the implementation of law. Not the formation of law, but the implementation of it. So the moment we talk about the historical background of the country to talking about loads of social exchanges, so talking about a lot of age ascription culture, which is that if people are of a certain age, they are elder to you, you are supposed to abide by whatever they say and never argue. Arguments are not considered as a roadmap to agreements, but arguments are considered as roadblocks. And that's exactly where the whistleblowers that need to express more, the need to argue, and that stimulating intellectual discussions are the need of the hour. But most of these students find these missing, whether we talk about at their homes or we talk about even in their schools and colleges. Because the social culture here doesn't promote, rather, it prohibits those intellectual discussions, those standard conversations that are really going to stimulate the multidimensional aspect to a particular problem. So even though we talk about why do certain things happen, why can it not be, so that radical shift into thinking is usually missing. So talking about right from the, again, one of the most significant aspect is the economic part. So the ones who have more of the financial prowess are exactly who are going to determine their progress. So this process of progress is exactly where we need to hit. Now, to talk about the whistleblower's vital voice. Now, how does that happen? When we are taking the courage to reveal something which has happened to us unethically. So, there's a lot of gender power that we have. So, the gender dynamics, or I would rather say gender power dynamics, is very high into the country. So, if a female would like to voice out that yes, something wrong has happened with her, there are a lot of social challenges that are lurking onto her mind before she really thinks of giving it the appropriate words. And even though the words are appropriate, the message is totally misconstrued. Not only that, when we talk about the catalysis, so when we talk about coming up with loads of investigations to push and change, so there's a lot of pull from the society that one should refrain from talking about and even thinking about justice and equity. So these are just the principles which are mentioned into scriptures and books, but once we talk about their applications, exactly those need push. I would like to talk about the student aspects of the whistleblowers, wherein they need to voice out that change that they require. Because students are the ones who are going to further beget the generation. So the next upcoming generation will not follow their grandparents or even their parents, but they are going to follow their friends. And that's exactly which is something common to everyone across the globe. So it's not only India, it's not only this part of the world, and championing for change requires exposure of those issues, and social media here is doing an excellent job. So when we talk about the special social media features such as posting up of a story to talking about putting up reels, how do people suffer from loads of emotional challenges and those emotional first aid needed, to talking about that psychological help in the form of counseling, to taking themselves across through loads of self motivation. So there are a lot of power imbalances that every individual needs to manage. Well, there are significant barriers that every individual realizes not into the physical domain but into their psychological aspects. And that's exactly where loads of challenges come into their domains of professional counterparts. Not only that, when we talk about a peer does not work with peer, they are usually working against each other. And therefore, the concept of team building usually is just again a concept, and people really struggle, especially those organizations wherein they are fighting with each other to achieve goals rather than they are working in a team setup that they can achieve their goals easily and faster. So, whistleblowers, once they talk about their psychological changes, and I would like to introduce the personal spoken cases of a few clients who mentioned that they had loads of issues when they wanted to voice out their mental concerns, especially during COVID, that they had tough time to deal with the socialization once again. So getting re-socialization done for themselves, especially when it came about marketing, to talking about their concerns, whatever they had felt. So at times listening is healing. But whistleblowers do not become whistleblowers probably in case they are heard well. So to talk about some of the corporate landscape that, yes, the whistleblower cases had been prevalent, these are the few prominent ones, which includes Enron scandal, which I think is known to one and all across the globe. If I want to talk about the Flint water crisis, again, that needs no mention here. We already know what happened with the Michigan's water supply, to talking about the Cambridge Analytica scandal. But once we talk about the Facebook users, that yes, those had that privacy issues, everything went viral. Now, with this, that yes, there are loads of issues to everyone, and then they decide whether or not to voice it out. And yes, it begins, the whistleblowing concept begins with questioning, that interrogation, and not only observation of the society, but loads of self introspection, that is there something wrong with me? Or should I really, and that self acceptance and self approval, should we really voice out the concern that we are facing? So here I would like to share a personal case, the causes, the repercussions, and the proposed solutions of a real-time case that came up with one of the student clients to me. So I have uh, taken up a pseudonym here. This is not the real name of the student. So I would like to tell across that there is an academic retaliation that this girl faced when she wanted to voice out her concern that she was not finding herself comfortable into the classroom. Now, the school student was facing a lot of challenge whom to speak up to, and again, her parents coming from the similar social and mental block had suggested her not to really consider it as important, that yes, she was being discriminated basis her gender, basis her skill set, that she took more time to understand the similar concept that the other students did not really take along. So they did not take a long time understanding those concepts, but Ria was taking long. And therefore, the moment she start, and when there was a question, there's a concept of the school taking a feedback from the student, she fairly wanted to voice it out that she had this issue of not really understanding well, and she wanted some repetitive lectures. However, her case was unfairly scrutinized, and she was accused of academic dishonesty without evidence, that yes, there is no gap between the teacher and the student delivery. Talking further about the social isolation, her peer and faculty members started to ostracize her and talking that, oh, probably you are not somebody who is fit to fit in into the society. And she faced a lot of bullying and exclusion from her own group activities and projects. Their group members started to ostracize her. And not only that, she also had the threat that she won't be given the similar degree, that pass marks, and therefore she will continue to suffer, which caused her a lot of significant social stress and the financial burden, because she never wanted to repeat the year. Because at the moment they are not claiming the essential credits of their course curriculum, definitely they would have to repeat. And this is exactly what she was not looking at. And last but not the least, the emotional and mental token of stress that was coming up as the constant pressure and isolation took a toll on her mental health, leading to anxiety and depression. What do you think could be the solution for her? How could she really put her case and not really get her instances jeopardized? I would like to share the repercussions that she faced, which included the grade manipulation. Certain students were receiving disproportionately high grades despite their poor performance, but poor she, being right, just taking some more time to understand the concept, her grades were totally tampered. She did not feel that she was scoring what she really deserved. The exam papers were questions were somehow told to a selected group of students who had really cooperated with the institution. But before that, before she really came up with those exams, she had an unfair advantage. Not only that, to continue with the emotional and social currency, the loss of the psychology, the good psychology that she had, and the feeling that she had that probably once I'm going to voice out my concern, those challenges will be addressed. So her hope, her trust, and her friendship, the psychological safety that she thought she had, was totally jeopardized. And this toss of a coin has really led to loads of issues. And with this, I would like to talk about the untold and massive impact that this has on any whistleblower, and which I think has not so far been covered into the conference, is all about the psychological danger versus psychological safety. To talking about the fear of admitting mistakes and blaming others, these are loads of psychological dangers. At the moment I'm going to talk about something against the other person, they're going to talk 10 things about me, which is going to make my situation rather more dangerous, and therefore it is better to be quiet. How do you think, and how can this, everybody who is watching here, what do you suggest? I would like you to post in the comments, how can you really suggest the whistleblowers to come up with the solution to this? Not only that, there's a common knowledge effect. So, when we talk about the psychological safety, that is the comfort of admitting mistakes, learning from the other end into the form of that failures are the stepping stone to success, and an open criticism should be really accepted. It should be considered as a feedback, as a constructive criticism, and not as a blame game. So that shift into the psychological net is highly significant. Not only that, the better innovation and decision making starts to talking about everybody talking from the multiple dimension openly to share their ideas to how to make everything rather more significant and safe for the entire system to prevail, and not to consider anything or everything individually. This shift is required. So, with this conference, I would like to propose solutions to any of the whistleblowers who are connected at the moment, or probably who would be watching later on, that there has to be an anonymous reporting system by all the institutions. Most of them are really calling upon for the feedback, but which makes the person who is giving the feedback known. We would like you to implement secure and anonymous channels for reporting the misconduct, and to protect the identity of not only the whistleblower but also of that social or that professional institution which really wants to improve. So, all those institutions who are looking forward to improvement, please ensure that there is anonymous channel which is implemented and which is again not mentioned into the policies but is into practices. The second thing we would want as whistleblowers, and this is on behalf of all my clientele that I would like to share here, please have anti retaliation measures, that is, enforce strict policies against those who are retaliating. And not only that, those who are not cooperating with the whistleblowers should be penalized for their not so appropriate actions. Talking further, the ones who are going to reveal the anonymity and they're going to voice it out that yes, so and so person has given the feedback, even they should be included into the policies of a penalty or such actions which are going to ensure that whistleblowers are protected. Because whistleblowers are the ones who are really wanting a social inclusion. They have no other identity or a mindset to reveal anything wrong, but they all want everything to go right. So, what is wrong in being right and wanting right for the future generation as well? Because they really want that system to be intact for their safety. So, it's a proactive social behavior for any whistleblower, and that we want that should also be coming up with the global protection policies. Going further, we also would like to propose here from I, on behalf of the entire country, would like to propose that there should be some counseling services which is going to act as a mental safety net again for the whistleblowers, because they go for a lot of PTSD. So once we talk about that post traumatic stress disorder that they face when they are going to voice out those concerns, which others have opted and taken a conscious decision of not voicing out. So, if they are the ones, whistleblowers, who have taken up the courage to talk about equity, to talk about justice, to talk about inclusion, why should they be penalized? Rather, the people who are not wanting, the people who are doing wrong to them, they should be penalized. So, why is it that right is considered wrong, and why is not wrong put up right? So, do ensure that you have not only those legal net but also that support systems in place wherein the mental psyche of the whistleblowers are reconstructed once again, because they go through a lot of stress and anxiety. Going ahead, that we also would want the legal threats and to ensure that proper representation of the lawyers and everything into the country, because India is a country where loads of cases are still pending into the country. We would really want this legal aid to come from the policies and policies practitioners and the law implementers, that yes, the lawyers, the law should stand with whistleblower, not against them. Why should they continue to suffer? It's time for them that suffering should stop to them, and suffering should come to those who are discouraging the whistleblowers. With this, I would also like to propose the institutional barriers to justice and equity, which talks about the systemic discrimination, to talking about lack of accountability, the normalization of injustice, because as mentioned, and I would like to reiterate what was mentioned into the yesterday's episode, the session from the journalist who said that the injustice is totally accepted because we feel threatened to voice out. So therefore, why is it that whistleblowers have a weak social status? Otherwise, what they just want is a silence onto the corruption. So once we talk about these embedded issues, which are not exclusive but common to entire fraternity across the globe, why and when can we have this perpetuation of marginalization and inequality being addressed? So it's only and only through those systematic reforms that have to come in place, and not only in talks and discussion, but yes, each one of us supporting the other and standing with each other with accountability, that yes, that insufficiency won't be accepted, and adequate measures need to stand tall for the protection against all the misconduct and the abuse of power. So when we talk about corruption, and as Lord Acton said, that absolute power corrupts absolutely. So when and how can we have the distributive power? Not only that, once we talk about the resources disparities, so there are some parts of the world which are more developed than the other, and that talks about the social inclusion. So we really need to make and cut down on this normalization of injustice, those unfair practices, and that erosion of empathy, to everybody being more empathetic, and to come up with intolerance against any injustice happening to anyone. The moment we are all going to stand for each other, the need for legal safeguards are going to be reduced. So I would like to share here the personal cost of whistleblowing, which is all about and is much
Jyoti, we
known
need
to.
you to wrap it up. We're running over time.
Yes,
So
ma'am.
if you could just make some closing remarks.
Yes, ma'am. And I would just like to rest the case by saying that yes, these are some of those stencil examples by which we can put some end and some relief to the whistleblowers before the situation really becomes worse. So once we talk about right from equity to talking about inclusion and having that justice in place as well. So if whistleblowers, rather than to be more aggressive or to really voice out the concern to the legal authorities, or any of those competent authorities, if they are going to talk at their workplace, that yes, we've noticed the current approach, which we really don't intend to subscribe to, and we feel underrepresented and less respected, and we are looking forward to that social inclusion. So maybe please have your views on it. How can we improve the organization culture? To talking about how can we have more positive experiences for each other, wherein we can put to rest and have more of gender neutrality and color discrimination put at rest. With this, I also would like to rest my case and talking in favor of all those who are really going to exercise more of social justice, equity, and definitely inclusion. Thank you so much, ma'am, for the opportunity, and thank you all the sponsors for coming up with this conference. Thanks a lot.
Thank you. I think this was an important topic, and I loved your slides, especially the fact that you brought in students, because we were talking yesterday about integrity is cool, and that we need to bring young people into this conversation, because that's the only way to change the future, is to activate a younger audience to understanding whistleblowing in a different way than an older generation did, and to also bring into the conversation more of the disenfranchised populations, women, minorities, people of lower socioeconomic status. I think at the last UN meeting on anti-corruption that we had, not only did they do a whistleblower resolution, the resolution we were talking about yesterday about protecting persons making disclosures, but they also did a resolution on social equity. And it was really brought by the people of Ghana so that women have more of a voice, because this has been a predominantly white male access to justice, whereas women and minorities who cannot afford the attorneys, the legal systems, single mothers who can't take time away or can't lose jobs are more likely to become unwilling bystanders just because they can't afford the lengthy judicial processes that become whistleblowing. So I think these are crucial issues for us to consider when we think about whistleblowing from a global perspective. Are those whistleblowers who are silenced and become so invisible? So thank you for this today. And I think we're coming up on a lunch break. Ari, did you want to?
Thank you so much, ma'am,
Just,
for appreciation.
Dr. Kukreza, am I say it correctly? Kukreza.
Yes, sir.
Thank you so much. I'd just like to say to you that in Europe, the directive has been implemented, and we have both internal and external channels for a public disclosure. In fact, we have three ways of doing it: internal disclosure, external disclosure, and external disclosure via a media. And we also have the anonymous report keeping, which was a project, anonymous EAT it was called, which was a European program that actually was part of. And we specialized on the anonymous report keeping, and whistleblowers can do that without being traced. So it's been implemented actually in Europe.
Right. So, but into this part of the world, this is again an imagined reality. We are really looking forward to the similar application here as well, because the moment anybody would like to voice out for things to be equal for them, they are immediately socially excluded. So when we talk about that equity and inclusion, the moment we claim justice, we become wrong. So we are right only to the extent that we continue to endure the injustice happening to us, because that's what the country culture is. So maybe we have no hopes of improvement, or maybe we have to be accustomed and continue with the similar thought train that has been coming.
This is what we do, and this is my proposal
So
at the
when
end.
can we have a solution? That's exactly what we would like to propose.
And that's why we're working towards a global office of the whistleblower, so we can actually have an international treaty that is going to implement those minimum standards. But we'll talk about it later. Thank you so much for being with us.
Thank you so much, sir. Honored.
Thank you, and I look forward to seeing you in September. All right, thank you everybody for participating in the morning sessions. I think we've covered a lot of ground today, and we'll come back after lunch and we'll continue. I'm going to try to keep us on schedule, so maybe a little bit of an abbreviated lunch, and we'll come back, and there's delicious food upstairs. And again, thank you to our wonderful sponsors who are here today. Please wave. Where are our sponsors? See this man, take pictures and post with his integrity is cool. Yes, the live streaming, because there are people definitely watching all over the world. I've been getting messages about the live streaming. Oh, Digital System Solutions in South Africa. Jason is helping us today make all that happen with the IT. So thank you, everybody who's been working on this, and so appreciate all the participation. We need more events like this. You can hear there are people from around the world. I mean, besides here in Greece and the US, we heard about Germany today, India today. I wish Whistleblowers UK was here. I saw yesterday their legislation got introduced. So hopefully the first office of the whistleblower will be in the UK. Yes, thank you to Georgina Halford Hall. panels today that are going to take place here in this room, as well as the live stream. So we have to remember that the people who are tuning in on the live stream don't know what's happening in the room. They think they're logging in for a specific time to see certain panelists. So that's just a reminder, because I know we have a panel of, and it's a lot of people here in Greece, and they're coming in, and there'll be a lot of interaction. But then we also have to go to the live stream and the Zoom, because we have people logging in again from other parts of the world, and we have a full list of panelists today that we have to give them equal time. So our moderator for this upcoming session, I'm very grateful for my co-host, Aris Donikis, to come up. He's going to moderate our panel on the Greek case to talk about the success and failures in Greece. And we know, and we've heard already today, how it compares to different parts of the world. There are things here in Greece we don't have in the U.S., like legal aid. That was news to me. So if we could get you to come up, and we'll get started with the first panel of the afternoon.
Good afternoon. We're going to be speaking about the Greek case, success and failures. The Greek Whistleblower Protection Law 4990 of 2022 was recently published in the Government Gazette and is entitled as follows: Protection of Persons Reporting Violations of EU Law, Incorporation of Directive EU 2019-1337 of the European Parliament and of the Council of October 23, 2019, and other urgent regulations. It has been pointed out that the law in question transposes into Greek legislation an EU directive, thus providing a concrete legal framework regarding individuals who report breaches of EU law. The period during which companies are required to comply with the provision of law depends on a lot of criteria that we're going to discuss now by specialists. I would like to ask our first panelist, and it's an honor to have with us Judge Panagiotis Karakostantis. He is the judge at Athens Court of Appeal, appointed at the Special Legal Service Ministry of Justice, Greece. Mr. Panagiotis, you have the floor. But while he's getting ready, funny story. How I met Panagiotis. As a whistleblower who came to Greece, in 2016, there was a mutual legal agreement that I had to sign. And I don't know, you want to say the story, Panagiotis, or Masala? I think you'll tell the story better.
Well, you know, that's a very nice and interesting story. And
lift your microphone a bit up.
Yes.
Thank you.
It's a very interesting story on how we've met with Aris, and I would like to share this on this occasion, this story. Back in the day, I was an investigating judge in Greece, and I was responsible for all incoming MLA requests from all over the world. MLA requests are the mutual legal assistance from other countries to Greece in criminal matters. So I was usually handling EU cases in my office and neighboring countries as well. So MLA requests from Turkey, Albania, Northern Macedonia, Bulgaria, EU countries, maybe the United States, Canada, but I have never had the opportunity to handle a case from South Africa. So I had a case from there, from the land down under, and they were asking me to find a certain individual called Ari Danikas with no other information. I didn't have a father's name, a mother's name, a place of birth, a date of birth, nothing at all. And they told me that this guy made some serious accusations on corruption, on police corruption in South Africa, and we would like you to ask him whether he confirms this. Whether he confirms all this that he has testified in South Africa. But I didn't have anything to start with. I've sent them an email telling them that with just his name I couldn't do a lot of things, but my email was ignored completely. I've asked the police to get me a list of all the Danikas, all people with Danikas surname in Greece. It was about 250 of them, some living in Athens, some living in Crete, some living in Corfu, some living in northern Greece, and I didn't know where to start. So the easy thing to do was put the case in a drawer and leave it there. So I was focused on other more urgent matters. But as fate has a very big impact in our lives, I bought a newspaper, a Sunday morning newspaper in Kathimerini, and sometime after 2 or 3 months. And as I was reading the newspaper, in the page 7 of the newspaper, it was a full interview of Ari Danikas, the man who was brave enough to blow the whistle in South Africa about police corruption. And I said, oh yes, that's my man. So I called Kathimerini, that's the newspaper's name, talked with the guy that wrote the article. He's a journalist called Yannis Souliotis, and he's here with us today, and told him that I'm searching for the guy you interviewed, Danikas, so please give me his phone or inform him that I'm looking for him. He told me that he couldn't do that, but he arranged for his lawyer to come into my office, and when I talked to his lawyer and told him that South Africa is trying to locate Danikas and persuade him to give an additional testimony, his lawyer said to me that, okay, I'm going to inform him about that and I'm going to bring him to your office. So that's the way I met Ari for the first time. It's been 10 years back? Yeah, maybe 10 years back.
Give and take.
And after that, I had a personal relation with Aris because I thought that he's a very interesting individual, and he is a man that stands on his beliefs, and what he is doing here in Greece, trying to make people aware of whistleblowing and of their individual rights is it's a great thing to do. That's my story about how I've met Ari, and I am honored to call him my friend. Since you have already heard about things that are going on in Greek legislation about whistleblowing, I will try to make a very brief introduction about what are the whistleblowing provisions in the United States of America and what are the whistleblowing provisions in the EU, so we can have a way to make a comparison of what is going on. You have heard about the European Union Directive from 2019. What I would like to say about whistleblowing provisions in the United States is that the key protections that, the key protections that US law affords to whistleblowers in the United States revolve around shielding them from retaliation and ensuring their identities remain confidential. Under federal laws like the Whistleblower Protection Act, the Sarbanes-Oxley Act, and Dodd-Frank, employees are protected from adverse actions such as firing, demotion, suspension, and harassment. These laws mandate that employers must not retaliate against employees who lawfully disclose information about wrongdoing. Remedies for retaliation include reinstatement to the whistleblower's former position, back pay, compensatory damages, and in some cases, punitive damages. The confidentiality provisions are particularly critical as they protect the identity of whistleblowers during investigations, thereby minimizing the risk of retaliation. Financial incentives under the False Claims Act and Dodd-Frank also play a significant role in encouraging individuals to come forward with information on fraud and misconduct. These rewards can be substantial, offering whistleblowers a percentage of the recovered funds or penalties imposed on wrongdoings. We don't have this in the European Union. The combined effect of these protections is to foster an environment where whistleblowers feel secure and incentivized to report illegal or unethical activities. You have heard about the European Union Directive, and I'm not going to tell you more about that. And I would like to point out what are the key protections under the EU law. The key protections for whistleblowers in Europe focus on preventing retaliation and ensuring the availability of secure reporting channels. The EU directive mandates that both internal and external reporting mechanisms have to be established, allowing whistleblowers to choose the most appropriate channel for their disclosures. Protections from retaliation include a wide range of adverse actions such as dismissal, demotion, suspension, and any form of discrimination. Confidentiality is a cornerstone of these protections, ensuring that the whistleblower's identity is safeguarded throughout the reporting process and investigation. Member States are required to provide comprehensive support to whistleblowers, including access to legal advice, psychological support, and, if necessary, financial assistance. Remedies for retaliation may include reinstatement, compensation for damages, and other corrective measures. Those protections aim to create a supportive environment that encourages individuals to report misconduct without fear of adverse consequences, thereby enhancing the overall integrity and accountability within organizations. I would also like to point out that each individual EU state has applied their own laws about whistleblowing. I would like to tell you that there is a Public Interest Disclosure Act of 1998 in the United Kingdom. It's not technically an EU member, but back then it was. There is a Sapin 2 law in France about whistleblower protections enacted in 2016. In Germany, before the EU directive, there was no comprehensive national law, but protections were provided through various employment laws and sector-specific regulations. And I would also say that in the Netherlands, there is the House of Whistleblowers Act that was introduced in 2016. The differences between the EU and USA legal provisions in whistleblowers are as follows. They share the common goal of protecting individuals who report misconduct, but they differ significantly in their approach, scope, and implementation. The scope of coverage, the USA approach is characterized by a patchwork of federal and state laws that offer protections primarily within specific sectors, such as federal employment, publicity-traded companies,
and areas like healthcare and finance. The protections can be quite comprehensive within those sectors, but may leave gaps in coverage, especially for private sector employees not covered by state laws. In the European Union, the EU directive provides a broad, harmonized approach across member states, covering a wide range of sectors and types of breaches related to EU law. This creates a more uniform level of protection across different countries, ensuring that both public and private sector employees are covered. The reporting mechanisms in the USA, I would say that whistleblowers there often have multiple avenues for reporting, including internal company mechanisms, regulatory bodies, and direct reporting to governmental agencies. The choice of reporting mechanism can depend on the nature of the misconduct and the sector involved. In the EU, the EU directive emphasizes the establishment of secure internal reporting channels within organizations, with the option for external reporting to designated authorities if internal channels are ineffective or if the whistleblower fears retaliation. This structured approach aims to encourage internal resolution of issues while providing a clear pathway for external reporting when necessary. Confidentiality and protection from retaliation. In the United States, confidentiality provisions vary by law and sector, but generally there is a strong emphasis on protecting the identity of whistleblowers. Federal laws provide robust protections against retaliations, including remedies such as reinstatement, back pay, and compensatory damages. The EU directive mandates strict confidentiality measures to protect the identity of whistleblowers and comprehensive protections against retaliation. Member states must ensure that the whistleblowers are safeguarded from any adverse actions and provide mechanisms for redress and compensation. As for the financial incentives, as I've said before, one of the notable features of the US whistleblowing framework is the provision of financial incentives under laws like the False Claims Act and the Dodd-Frank Act. Whistleblowers can receive significant monetary rewards, which serve as a strong motivation for reporting misconduct. The EU directive does not generally include provisions for financial rewards yet. Instead, the focus is on providing protection and support for whistleblowers to ensure that they can report wrongdoing without fear of retaliation. And the last differences about support and advice. In the United States, while federal and state laws provide legal protections, the availability of support and advice for whistleblowers can vary. Some laws include provisions for legal assistance, but there is less emphasis on comprehensive support compared to the EU. The EU directive, on the other hand, requires member states to offer comprehensive support to whistleblowers, including legal advice, psychological support, and, if necessary, financial assistance. This holistic approach aims to address the various needs of whistleblowers throughout the reporting process. In summary, and I will close my presentation with that, is that while both the United States and the EU aim to protect whistleblowers, the United States relies on a combination of federal and state laws with sector-specific protections and financial incentives. The EU, on the other hand, has adopted a more standardized, broad-based approach through its directive, emphasizing secure reporting channels, comprehensive protections from retaliation, and support for whistleblowers. Thank you very much for your time.
Thank you, Judge. That was very informative. Interesting how you mentioned that the directive doesn't provide any provision for monetary rewards. Here is my dilemma, though. There's an Article 62 of Law 5104-2024 of Government Gazette that stipulates Greek legislation provides compensation to persons who report tax evasion, and the amount is up to €3,000. So, in essence, there is a provision for a reward, but it's a small amount. We try to keep it moderate. And what is interesting is the fact that the EU specifically mentions legal, psychological, and financial support for whistleblowers who suffer retaliation. We just don't know what happens while they're suffering retaliation and if they're going to survive while they have retaliation. But that's another discussion for some other panel. I would like to next call to the panel Yannis Souliotis. Yannis Souliotis is a Greek investigative journalist in Kathimerini Media News, and we go back a long way. Yanni, you have the floor. 10 minutes, thank you.
Okay, great. Thank you, Ari, for inviting me in this event. We've met back in 2010, 2009, something like that, while Ari was still in deep trouble regarding the events in South Africa. In 2016, I wrote a piece in Kathimerini regarding his case. To be honest, I was a bit reluctant. Sorry for that, Ari. Is he telling the truth, or is he a part of the problem? Finally, I found a way to verify, to check his testimony, so we end up writing this piece. And then Boyson, who was the police officer who was involved in the killings of black guys in South Africa, managed to somehow find me and sending me emails threatening that he would take legal actions and against me, but that's part of the job. So it's a nice development to be here and speaking about whistleblowers So I'm not really aware of the legal technicalities regarding the whistleblowing issue, but I could say that I specialize in crime and court reporting, so I would say a few things based on my experience. And the general outcome is that Greece is far from being a country which is friendly for whistleblowers. Let me give you some examples, starting from a recent case, which has to do not exactly with whistleblowers, but with protected witnesses, which is has some similarities, we could say, and it has to do with the recent investigation regarding Olympiacos hooligans. Before the investigation was completed, we, the journalists, were keep reporting, saying again and again that 3 or 4 or 5 people had testified with their ID protected. And when finally in late April, early May, the investigation had finished, and people were prosecuted, then lawyers, police officers, football fans, friends that who knew that I was investigating this case keep calling me and asking one question: who are those people who dare to testify? There was no, the question has nothing to do with what did they say, but who are they? And because Greece is a small country and Greeks love to talk too much. So soon there was a theory claiming that some young hooligans who were involved in the killing of a police officer, those were those who testified. And the outcome was that the mother of one of those guys a few days ago went to the police saying that every day she and her 3 kids are facing threats for their lives. And one of her sons, who is in prison, he spends time in a separate prison wing, so he's protected and not assassinated. A few years ago, in 2016, crime reporters, we reported on a police investigation regarding the so-called Greek mafia. The trigger event was the testimonies of another protected witness who helped the authorities to shed light to numerous killings, bombings, etc. But all of a sudden, we found out that the witness was not so much protected because we read her name in the court documents, and it was Litsa Vlastou, the close relative of one of a well-known mafia guy. And her name, even if she was supposed to be a protected witness, her name was left in the court files, the court documents. And Litsa Vlastou died 6 years ago. I'm not saying that he was assassinated, but the irony is that if you Google her name, I did that yesterday, you can find hundreds of articles under the title Litsa Vlastou, the Protected Witness. So I could keep saying examples, but I choose to finish with my a sort of a personal experience. While I was a bit younger, but still in the business, I met a mafia guy, and we become friends. And he asked me, he proposed me, Yanni, come to see how a Bravos, I don't know the exact translation, is painting...
Men for hire.
Sorry?
Men for hire to bully somebody.
Bravos.
Bravos.
Okay.
Not a thug, it's just...
So he invited me to spend a night with him, not the way it sounds, but... So I wore a jockey, so I could skip having eye contact with people I met that night. And what we did is that this guy had guns in small plastic suitcases, and we took a car, and we went to meet people. Apparently, they turned to be police officers who were working part-time as security also. And we met them in shopping malls, cinemas, even in some ministries that are in downtown Athens. And my guy were giving to them plastic suitcases with guns together with instructions of what they have to do during the night. So at the end, I wrote again a piece in Kathimerini regarding my experience, trying to protect his ID. And then the minister called me and asked me, Yannis, help me, please help us face this problem and deal with the corruption in the police division. And I said, okay, what do you want me to do? He told me, go find at that time, prosecutor who was in charge of Ministry of Interior, and tell him everything you know. And so I went to meet him, and the question was, again, not what did you see, but who told you that? Who showed you those things? So I think that Greece has a huge distance that needs to cover to become, to change, first of all, the culture of Greek people regarding the perception of whistleblowers or protected witnesses. And I think that the problem is highly related to the fact that Greece is a corrupted country. The level of corruption in Greece is similar to Latin America. So there's a huge lack of trust towards the authorities. For many years, for up to 7 years, the police unit that was responsible for tackling the corruption was controlled by corrupted officers. So you cannot ask, and you cannot wait, you cannot ask someone to go and share some information with the authorities when the authorities are corrupted. And yeah, I had notes about, and okay, I will say that. And in 2020, 2021, we, with help of Aris, we did a short documentary on whistleblowers. And at that time, we went to interview people from the National Transparency Authority, who was, let's say, in charge of creating the legal frame for protecting whistleblowers. But since then, the National Transparency Authority, when tried to investigate some very, very serious cases in Greece, like the wiretapping scandal, or even the situation of the Greek railway that ended up in Tebi accident, find nothing wrong. So, again, this is a damage to the credibility of the authorities that are made for the protection of whistleblowers. So maybe the legal framework is very important, but we have to focus on some other aspects of that issue. That's it. Thank you.
Thank you so much. Wow. So I'm processing this. Just for our international viewers, Yannis Suliotis spoke about the Olympiakos hooligans. We're referring to violence between soccer groups. It's a problem here in Greece. Our next panelist, he is online. There was a change. Dr. Angelos Kaskanis, he is the Executive Director of Transparency International Greece. He was supposed to be here in person, but he had an accident, and he's going to speak from his recovery place. Angelos, I hope you feel better. Can you hear us? You are muted. Unmute your microphone.
I'm unmuted, but can you hear me?
Yes, we can. Go ahead. The floor is yours.
Perfect. Thanks a lot. Thanks a lot, Aris. Thanks a lot for the understanding and well done. Thank you, and well done in monitoring all this, organizing, be the man behind the scenes, and also in front of the floor. And for all of us giving the floor to share our thoughts, to share our concerns, and also our suggestions of what we see as the Greek legislative and the Greek case in general today. So I will, before jumping the legalities, as we say, like to take it from the comment that Mr. Suliotis said that the Greek public administrator or the Greek, let's say in general, I would say society is not ready to hug or to host such a sacred notion as the whistleblower. And I say this, that taking under consideration that even the Greek society has a word instead of the whistleblower, they call them Rufianos. And for years, they were considered as a black sheep, they were considered harmful, and they were considered people that are disruptive in a negative sense. Someone that wants to disrupt the system, the calmness, the whole process, but in a negative way in order to earn something, in order to proceed with their personal agenda. So things have changed, thankfully. And the new generation perceives the whistleblower and in private sector and also in public sector with a different notion. Indeed, as Mr. Suliotis mentioned, there have been several cases in Greece that are very disturbing, very worrying, that have been also discussed in a European level, and we are not very proud of. but in general, I would say that Greece, alongside with Portugal and Czechia and other Central European countries, are the ones that when they introduced the directive in the Greek legislative system, they did the minimum. And by saying the minimum is that although there was a tension and the discussion with other civil society organizations such as Fully Watch, Reporters United, and unions, since 2013, 2014, after 5 years of discussions, open panels, fora, etc., we lost, I would say, historical opportunity to be more bold, to be more disruptive, and to serve better, as I said, the notion of being a whistleblower and adding value to the Greek society, and be an example, I would say, for our region. Our region, Southeast Europe and the Balkans, that suffer a lot from several similar cases, I would say, of publishing or disclosing the personal information of the whistleblowers, of harming them, political assassinations, etc., etc. So, being a whistleblower in the region is quite tough. I would add, quite tough and quite unfortunate in some cases, bringing to the person the dilemma of being an asset to their society, to being an asset, or rather turn the eye and never share what they have experienced or what they have witnessed. I've prepared some comments regarding the legislation, regarding the directive on whistleblowing, the law 2019/1937, and also what was the law 4990/2022, but also what Ari shared about the tax evasion of the law of 2024, which I would say it's the first step in order anonymously to blow the whistle, to report tax evasion, and to introduce to the Greek public a massive opportunity for them to declare some irregularity or some evasion. But in general, I would say that promoting transparency and accountability in both the public and commercial sectors requires a strong whistleblower protection that we don't have. The introduction of the legislative was a milestone, and the breadth and the provisions of the Greek law were subject to some restrictions and criticism nonetheless. This was also coming from the Greek government. So regarding the scope of the law, with regard to its regulatory notion, covers, any addition, only the reports about breaches of particular sectors of EU law shall enjoy the protection of the directive. This legislative path is regarded by us as not compatible and also not best practice in whistleblower protection. Let's say applicants for jobs, self-employed people, consultants, homeowners, shareholders, members of the company's administrative management, etc., as well as anyone working under the supervision direction of contractors, subcontractors, suppliers, are eligible for benefits under the law, so there has to be a connection. Additionally, it should be highlighted that the law permits anonymous reporting by offering some level of protection to anonymous whistleblowers in case they are discovered at later time. So individuals who, let's say, deliberately hinder or make attempts to hinder whistleblowers from disclosing unlawful or unethical conduct will face criminal penalties according to the law. Potential whistleblowers may be, it's noted that may be intimidated, threatened, or coerced as a result of these behaviors, which foster fear and silence. Of course, such conduct not only compromises the reporting procedure, but also perpetuates a culture of secrecy that hinders effort to bring this conduct to light. As also Mr. Suliotis mentioned, we see the names of whistleblowers being publicly disclosed, but also it is we have noticed that there is a tendency of the public sector to ask repeatedly who the person is. So we are not examining the case, we are not focusing on the case, but of course the whistleblower is a member, is part of the case, but we don't focus on the case per se, on what is being reported, but we are focusing on the nature, and we are trying to dismantle the whistleblower. We're trying to bring him or her or whatever to under the spotlight, and the whistleblower, from the one that blows the whistles and brings insights and useful information to the case, is the accusant. So we don't really understand why this retaliation culture and this malicious culture is so wide in the sector. For us, protecting the confidentiality of whistleblowers is crucial to ensure their safety and current reporting, and the law, as in general, recognizes this importance and explicitly prohibits any infringement on the obligation to respect the confidentiality of whistleblowers' identities, which in practice, let's say, is not fully respected. And again, there is also notice about the false reporting and public disclosure, and which we find crucial. The law recognizes this and establishes both criminal sanctions and monetary fines for individuals who knowingly report or publicly disclosure false information. Second. So I will go to, I would like to add one positive. I understand I have 2 minutes, so I will focus on one positive, and also I will focus on future suggestions. So Greek legislation, specifically law 4919/2022, encompasses provisions for reporting monetary laundering activities. For the first time, the inclusion of money laundering reports within the scope of this law is a critical step in identifying and preventing illicit financial transactions. Although it is a step in the right direction, that money laundering reports are now covered by the Greek law, there are still issues that need to be resolved if the law is to be even more successful. There is a matter of comprehension, and there is also a spot for suspicious transactions that properly reporting them. And regarding our suggestions, and to wrap it up, we propose that we need immediately to widen the scope of reports. This also includes whistleblowing protection, which means that in essence that the whistleblower should be in practice should be safeguarded in order to minimize ambiguity and reduce the risk of insecurity for individuals that are considering to blowing the whistle. We should learn from the private sector. Private sector in Greece has done huge steps towards the right direction to our understanding. There should be access of reporting channels to every individual, and this should be clear that they will not be violated whatsoever. And I will close it here. I think I'm just
we can hear you.
Yeah, I think I'm just like I
Okay.
just finished. Like,
Angelos, thank you so much for your constructive and expert inputs. We really appreciate it, and taking the time from probably being pain because of your injury. Thank you so much for everything. And well done to Transparency International Greece for their work they've done up until now.
Thank you so much.
I would like to call to the panel Maria Nathanael, Head of Communications and Legal Analyst from Vouli Watch, that's Parliament Watch Greece. Maria, you have the floor, 10 minutes. Thank you.
Thank you, Iris. Thank you for the invitation. It is a great honor to take part in this panel among such esteemed members of the journalistic and civil society community. The defense of the rule of law does not stop at rhetoric, but insists on legality, equality, and legal certainty. This must begin with the protection of the right of citizens to report violations of the rule of law principles. The safety and confidentiality of whistleblowers is a shield and a weapon against opacity and all forms of arbitrary behavior on the part of public authorities and private interests, as they are the vanguard of social actors and citizens who support the accountability of the state, who want transparency in the functioning of institutions, and who insist on fighting for the strengthening of democracy. As the principles of the rule of law have been eroded and undermined in recent years in Greece, and even in traditional Western democracies, effective, strong, and extensive legal protection for whistleblowers is the last stronghold against corruption and the entrenchment of business and political elites through opaque relationships. In Greece, at a time when whistleblowers are publicly vilified and the last independent journalists are under direct attack, plagued by unfair slap lawsuits, and when opacity and corruption in the use of public money has become an entrenched normality, the incorporation of the European Directive on the protection of whistleblowers should have been a major priority rather than a mere institutional obligation that could wait. The long-awaited draft law for the transposition of the directive of the European Parliament and the Council of Europe was submitted by the Ministry of Justice in October 2022, discussed in the relevant committee of the Parliament, where Vuli Watch intervened, and finally passed as a law in November 2022. This bill arrived in Parliament long overdue, after 7 months of delays following intense lobbying by Vuli Watch and the Greek civil society. In June 2021, we embarked on a campaign and sent a series of letters asking for updates on the progress of the work of the Legislative Committee. We received no response. In December 21, just before the deadline for the transposition of the directive, the members of the Alliance raised the issue again with articles and social media campaign. Nothing happened. In March 2022, we learned that the Minister of Justice had presented a draft law to the Council of Ministers, but after a lot of opposition from some ministers and members of the New Democracy Party, the Prime Minister withdrew it. Just weeks later, the OECD evaluation report entitled Implementation of the OECD Anti-Bribery Convention was published. There, we discovered to our great and unpleasant surprise that the Greek authorities have misleadingly stated to the Working Group on Bribery that they invited civil society to assist in the drafting of the law and that we did not respond. The same report notes that the government had committed that the draft law would be posted for public consultation and tabled in Parliament in the first quarter of 2022. In the end, the draft was submitted and passed 7 months after the deadline, and despite our own urgings, was ultimately a missed opportunity for the effective protection and encouragement of whistleblowers in our country. It is a law that is obviously restricted in parts when it should have been structured more decisively. Allow me to refer in more detail to specific provisions of the law, which we pointed out during our intervention in the Parliament, but which were all finally ignored. Point first, the bill does not cover violations of national law and public interest. Despite the explicit recommendation and encouragement of the directive in this direction and the corresponding good examples in other member states such as Denmark, Portugal, France, Sweden, and Cyprus, the scope of the law remains limited to violations of European law and does not extend to national law. Also, the scope of application does not cover criminal offenses, corruption, fraud, for example, bribery of public officials, concealment of offenses, cases of miscarriages of justice, conflicts of interest, abuse of power, violations of the laws regarding access to information and open government, mismanagement of public funds, violations of the Code of Administrative Procedure, violations of human rights, etc. All violations that relate to matters of public interest and that unfortunately we often encounter in our country. The second point is that the protection afforded to whistleblowers is incomplete. Article 17 sets out the objective of maximum protection of employees and those under a duty of confidentiality against retaliation, meaning protection against any retaliation as a result of disclosures. We believe that this protection is not sufficient and that there should be encouragement in advance by providing financial incentives for employees to whistleblow safely. The safeguard in this regard would be that money would only be awarded if it is proven that the information was true and thus avoid any misleading information or abusive behavior. A further problematic issue has to do with the fact that the law does not make it clear whether anonymous reporting can be made. Third point, there is no provision for the possibility of confirming the filing or complaint. According to Article 12, whistleblowers do not have the possibility to check and confirm whether what they orally reported to the competent authorities was fully and correctly recorded. Fourth and final point, we believe that instead of broadening the provisions, they have been narrowed. Firstly, the infringements defined in the bill, contrary to what the directive provides, do not include abusive conduct or acts. Secondly, the period of protection of the whistleblower's identity is very limited. And finally, there are no sanctions for legal persons, only for natural ones. In conclusion, we as Woolly Watch would argue that the state must create a clearly more effective and modernized protection grid so that whistleblowers who go above and beyond to defend justice and truth are not crushed at heavy personal cost. This is a one-way street for fighting corruption where it occurs, for strengthening human rights where they are at stake, and if not for the progress, at least for the preservation of democracy in general. Thank you very much.
Thank you, Maria, for this comprehensive report. Our next panelist will be Mr. Panagiotis Kranidiotis. He is an IT engineer and a member of the board of directors of Open Technologies Islands, GFOS or ELAC in Greek.
Alliance.
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 Thank you.
Thank
The
you,
floor is yours.
everybody. Thank you, Ars, for the invitation. I will tell you today, I will base my speech on two stories. The first one took place in Istanbul in 1955, and it's an event that took place there and called Septembriana. It's actually the Greek version of Kristallnacht, the night of crystals.
Can you repeat that slower so they can all pick up the name?
Okay, Septembriana. It's the event of September of 1955 that took place in Istanbul, in Turkey, and it's the Greek version of the Night of Crystals. And the story is that a mob controlled and organized by the Turkish deep state itself, as is revealed later in the trial of the then Prime Minister Menderes, destroyed properties, businesses, and churches of Greek residents of Istanbul. Events that are accompanied by hundreds of rapes and murders. This fact would not have been known if the Orthodox Patriarchate photographer Dimitris Kaloumenos and the journalist Sakis Karagiorgas had not managed to photograph and illegally channel abroad the evidence of this crime, which was the beginning of shrinking of the Greek community of Istanbul. Kaloumenos was tortured and was likely to be deported for lack of evidence. Apparently, he could never be obtained as a photographer of the Patriarchate. He continued his life far from his hometown, Istanbul. He worked in Athens, but he never returned to his city. The second story, it's the story of Kostas Tsalikidis. Tsalikidis was an IT engineer at the telecommunication company Vodafone. 4 days after the outbreak of wiretapping scandal, a number of political figures, including the then Prime Minister, as well as Greek Secret Services officials, Tsalikidis was found hanging at his home. The case was characterized as suicide and was closed in a short time. Over the years, it had been proven that Tsalikidis was murdered because he knew about the illegal activity, probably with the involvement of the Secret Service of a very powerful country. Kaloumenos was a whistleblower of his day. There are interesting takeaways from both stories. First one and basic. Kaloumenos was a conservative man with a very special and good job. He was the Patriarch's photographer, not an ordinary job. The moment he decided to immortalize the crime of September 5, his life changes. He'll never be the same again. His life is in danger, his family's too. Kaloumenos is getting alive from all this. Tsalikidis does not. We must know that, and you know better than everyone, that a whistleblower's life changes the moment the evidence is leaked. That's why whistleblowing is not something trivial. It's not nailing. Just as it's wrong to urge people to nail each other and for it to be something socially acceptable without consequences. The public interest is a man who sacrificed his possibly comfortable life for a high cause, for some high values. Anything else would lead a society without trust, without bonds, without ties. Just as a society without witness of public interest is a society in which there can be no justice, even if the institutions responsible for this have become compromised. And what makes the difference is precisely the human factor. It is the unpredictable behavior that will wake up from the moral values that people should have and will act out of context. The public interest witnessed cannot continue their lives, but they must have the right to live. They must have the right to rehabilitate. They must have the right to be able to at least rebuild their life in the same or in another country. And since the danger to their lives comes either from the state entity, they live in case of Kaloumenos, or in case of Tsalikidis from Secret Service of one of the most powerful countries on the planet, three parameters are important. First one, the protection network must be global, must be international, and there must be the possibility of choosing the whistleblower to choose the country of residence. Second, in each country, the protection structures should not be state-owned, because state, most of the times, maybe, especially in countries like Greece, where there's a lot of corruption, is involved in the procedure. So these institutions should be either judicial or independent. And third, I think that it should be at least more than two in each country, so that the witness can have a choice. Regarding the technical details, especially about the data collection process, it's especially important to avoid any information that could reveal, and all the colleagues that they mentioned this already, to reveal the identity of the witness. Nevertheless, and especially at a time when artificial intelligence has given new possibilities to research, it's certain that sooner or later the source will be revealed. So there must be the time until the information is made public, must be such as to allow for the protection of the witness to rehabilitate. Finally, a particularly important element must be the security policy implemented by journalists engaged in investigative journalism. The level must be particularly high. The use of open technology is probably the only way to ensure the absence of backdoors from vendor company, and security, anonymity, and lack of logs must follow the journalist at every step. It should be second nature to them. We have had the opportunity as an organization to work with many of excellent journalists, investigative journalists of all this time, and we will continue to do so in the future. So that's all for me. Thank you very much.
Thank you, Panagiotis. That was enlightful. And something you wouldn't know, we had one of our oldest Greek whistleblowers from 1995, Kalloumenos, who was a photographer. Our next speaker, and I think it's a final speaker of this panel, the Greek case, it's Vasilis Stamatopoulos. Vasilis is the CEO of Fraudline Whistleblowing Center in Greece. The floor is yours.
Thank you, Aris. Thank you once again. Good afternoon, everybody. Again, thanks for the invitation. So I will show you some of the present, some disappointing facts from the present, and some, hopefully, optimism, from the future. So what's happening today? So there is a survey, which happens every couple of years, is the Eurobarometer, and gets the citizen views on corruption in the EU. Last year it was conducted, it was 2013. It's for all Greek countries. And so I will show you some facts from the Greek, let's say, info sheet. So the facts are devastating. We have 97% of the people think that there is a widespread problem of corruption in Greece. That's the highest in Europe. The average in Europe is 70%. In Greece, it's 97%. Could be 100, really. I think it's as high as it can get. So 56% of people believe that in the past 3 years, the problem of corruption has increased. So that's really disappointing as well. So let me find. Okay. In Greece, do you think that giving and taking bribes, envelopes, and abuse of power for personal gain are widespread in the following? Political parties, politicians, officials. So that is quite high. The European average is the blue. The Greek is the gray one. So we are far higher than the average EU statistics. It's only private companies, that were a bit lower. So Greek people trust private companies. So, for the following, please indicate whether you agree or disagree. There is corruption in national public institutions in Greece. 74 of people believe strongly this. It's 73% for regional public institution. That is extremely high and much. No, it's 92 and 92. 73 is the European average. So, for each of the following, indicate whether you agree or disagree. You are personally affected by corruption in your daily life. So, we see that 56% of Greek people are personally affected from corruption. So, in the past 12 months, have you experienced or witnessed any cases of corruption? Yes, it's 9. So, in addition to official experiences, did you give extra? Did you have to give extra? So it's 97% of Greek people have believe that they had some personal experience of corruption in their daily life. So, some more statistics. I will not stay in that. That's really devastating. So, we are one of the worst countries in Europe regarding these statistics. Some people would say these are just perception. Of course, it's perception, but comparing the perception to the perception of other countries shows that there is some problem. The problem may not be as high as the statistics indicate. However, it's a very good indication that there is some underlying problem. So, what is the solution? There are a lot of solutions. We have to work on multiple levels. As a company, we implement complete whistleblowing systems, policies, processes, trainings, whistleblowing platforms. But through our experience, we have found out that we need to work on younger ages. From the people who have trained, we see that the younger people are more receptive to this type of messages. So we put together an international program with 4 Balkan countries participating, which is called Future Integrity Leaders. And we have an initiative, Integrity is School. In the framework of the needs analysis of the program, we have conducted a survey of 400 young people that are in education or just finished education, and we have also conducted 4 future workshops in each country just to see what we can do about integrity in education. We believe strongly that integrity now in schools will be integrity in future employees and future societies. So, a few things about the program. So, it's about pushing, an integrity culture in educational institutions and more specifically in schools. So, through the survey, how important is integrity education in schools? 47% found, told us of the 400 people that participated that is extremely important, and the other 26% that it is very important. So, should integrity education be compulsory in school curriculum? So, 88% of young people participating told us yes, it should be compulsory. So, what are the problems, that people are facing? I will show you all 4 countries because we have some variations. We have theft, bullying, sexual harassment, gender discrimination, cheating, plagiarism, vandalism, racism, socioeconomic discrimination, school elections, peer pressure, students to teachers, verbal or physical abuse, teachers to school children abuse. So these are the statistics for North Macedonia. These are the statistics for Albania, Bulgaria, and Greece. So, for example, in some countries, vandalism is not a problem. In Greece, it's a huge problem for schools, institutions. When we told the people of Bulgaria about vandalism, they said, oh, nothing is happening in our school. Everything is clean. Everything is not broken. So we have some trends, of course, bullying, for example, or sexual discrimination in some other countries. But there are some differences that we have definitely to take under consideration. We're trying to tackle a problem at a national level. So people ask, how do they envisage, integrity education in school? So classroom lectures, online courses, role-playing, group activities is the highest, together with classroom lectures, discussion-based e-learning, experiential learning. So everything is more or less accepted, but we have some preferences that we also have to take into consideration because we're going to develop material. And it's in which way, do you think the school curriculum should include integrity? 52% told through other subjects. Just having an integrity, let's say, lecture, or a lecture on integrity, or a program on integrity, sometimes is not good. We have to put integrity in mathematics, in economics. The economy is affected in mathematics, to show about the losses of, in terms of monetary, losses of society, in sociology, in chemistry or physics or environmental, for example, the Dieselgate scandal. We can explain to people how the environment is affected by some kind of corruption in the car industry. So just not to have just a, let's say, boring lecture on integrity, just to be, advocates of ethics and integrity, but just to show them in practical terms through other subjects how we can implement such actions. So the potential obstacles, of course, there are many: limited resources, lack of awareness about the importance of integrity, resistance from students, resistance from parents, resistance from teachers. This is quite balanced, I would say, the resistance. There's always resistance in our societies. Difficulty integrating into existing curriculum, and lack of effective teaching methods and materials. So beyond the need to create the education programs, it's also important to promote a culture of integrity through encourage of self-reflection of students, providing opportunities for volunteering, creating an open channel of communication, enhance leadership skills to both teachers and students, and strengthening the support of teaching staff. In the workshops we did, we conducted some futures studies in terms of just to people to reflect their future, just to know what the consequences of today, of their actions for today, will be for the future. So the methodology included to take under consideration these mega trends, as we call them, which is diversification of education and learning, increasing demographic imbalances, aggregating resource scarcity, accelerating technological change, like AI, for example, widening inequalities, increasing influence of new governing systems, climate change and environmental degradation, changing nature of work. So we need to take under consideration these megatrends. Just, let's say, teaching about integrity in a sterile environment is not really very good, because it's never going to happen. And we also have this grid. We are looking at a society that is based either on trust, scenarios that emphasize trust and rely on integrity of people, or control. You can trust people, or you can put a lot of controls on them. Or individualistic society, scenarios where the society prioritizes individual contribution, competition, and personal success. And also the collective society, scenarios where the society emphasizes group collaboration, teamwork, and collective achievement. Everybody could be in this grid. So, a typical scenario that came out of these productive and very interactive, let's say, sessions from teachers, students, and parents in all these workshops that we had all these groups. So, regarding this grid, for example, in, let's say, trust and individualistic, we had students and teachers do not collaborate. Advancement of individual knowledge and skills, less corruption because of trust. Or students involved into simulation games where they assess different cases, all focused on levels of collectivism and collaboration. In this grid here, we had attendance at elementary schools is compulsory by law for children under 8 to 15 years old. Teenagers, average 16 to 19 years old, have the autonomy to select their education path. So we have collective society and more control. Anyway, this is just indicative. We had 16 of these types of scenarios where, in the report we will have all of them for you to study. We have some key themes across all scenarios. So, educational models are evolving with physical schools integrating AI technologies. Virtual schools through fewer rely heavily on AI, parental involvement is observed, resistance to technology exists, mixed environments blending physical and digital elements. So I will not go in very much detail because there is a lot of substance and detail here, but we will go to the policy recommendation that came out of this from the students. It's not from us, everything that, came out of these workshops. And us, as, let's say, advocates of integrity, we were not very heavily involved. We wanted to be, not very much biased. So it's the Foundation of Research and Technology, Hellas, the Research Institute, conducted these workshops. So we had integrity versus corruption, cracking the code, to have fun-filled seminars of integrity and corruption awareness. Having fun is very important. So to team up, to make groups, to boost collaborative learning with interactive storytelling adventures in the classroom or outside of the classroom. We have to start young. The younger, the better it is. We targeted high school children, but going to primary or even before that is advised. So to spot the corrupt behaviors, because framing the corrupt behaviors is very important in children who have the good guys and the bad guys in adult life is not very much clear. So we have to have seminars for students and parents how to identify the risks and dangers of bad activity. So to have experts insights, to have training of teachers, this is very important because we have to, first of all, to train and the teachers to become aware of these issues. So the schools also have to team up, individual schools just protected the environment, protected private school or public schools. The teachers, schools also, they have to come together and have group activities on these topics. To have some DIY learning fun. It's not only about, classroom or interactive. Sometimes you have to have gamified experiences that somebody can do themselves. Parents also, we have to get parents involved because we're missing a huge part of the equation if we isolate parents or parents believe that they are not part of this process. AI adventures, just to explore the AI possibilities, just to use AI for good and use AI in a good way. Mental health is also important to promote mental health through these activities because if we are suffering in this compartment, it's very difficult to promote societies with integrity. And last but not least, this came up without us, let's say, pushing it or enforcing it, just to have reporting mechanisms in schools. This is extremely important. Sometimes, even myself, I believe, that having kind of whistleblowing lines in schools sometimes can be too invasive. But this year, for example, the Greek government put together a whistleblowing for bullying in schools. But this also came up from our workshops. So whistleblowing should be part, of course, should be adapted in a certain way, but children have to become aware because as adults, there will be good, let's say, employees, good entrepreneurs, ethical entrepreneurs, but it will be even better when they have used or they are aware of this type of, let's say, integrity mechanisms in their school life. Thank you very much for your attention.
Thank you, Vasilis. That was extremely interesting. Your approach is unique because what we established today on the Greek case success and failures is the fact that we do have a problem, a major one, and the obvious. And we have a culture problem. We have a cultural issue, understanding where we're standing in terms of corruption. What is the problem with that cultural acceptance of corruption? And what Vasilis is pointing out, that we have to go back to education. We have to educate our children. We have to have anti-corruption education programs at schools. And really, it's for the future generations. It's for our children to understand that in order to fight corruption, we need not to be afraid to speak up. And that's why we need whistleblowers. That will be the end of our panel. we have a bit of time, so a few comments. I mean, there's a lot of information to process. Do we have any questions? Okay, Vasily. Το πατάς από πίσω. Hold the button.
I think it's working now.
Yeah, I would like to mention European Parliament verdict of 7th February 2024 over severe concerns of status of democracy in Greece. So the European Parliament, all members of European Parliament participated on this voting and decided that the status of our democracy here in Greece is questionable. Thank you very much.
Sorry, your name is, just for
I'm Manolis Alifierakis. I'm the first ever assigned as whistleblower in Greece. I reported the manipulation of electricity market of the country, and today Greece has the most expensive electricity rate all over Europe. I was fired. The minister in charge has never investigated, albeit the prosecutor of Supreme Court forwarded the case to the Greek Parliament. That was back in 2013. I was assigned as a whistleblower on April 2015. The protection was removed by an irrelevant prosecutor, and then I was fired by my employer, who today 49% of the shares are on Macquarie Bank of Australia, and Australia is also correlated with Julian Assange protection and rights. So there is a lot behind.
Thank you so much. Thank you.
Thank you.
Thank you.
So, you know, a few notes that just stuck in my mind, and this is like, we shouldn't have an institutional obligation, okay, to implement minimum legislation, but we should actually do more as a nation to improve the EU legislation. I think the directive, and it was Judge Panagiotis that mentioned that the directive leaves room for improvements on any national stage. So instead of us as a country, and that's my conclusion, doing more to improve public disclosure acts in Greece, we implement minimum legislation, and we did in theory, not in practice. That's something of a concern. We need to invite more civil societies to participate in this kind of action, and the government needs to listen to NGOs more often. We have lost a historical opportunity to make progress in Greece. I realize that Greece takes small steps, baby steps, on those kind of implementations of the directive. With that, let's close this panel. Would you like to make a few comments? We're a bit ahead, so we can have some.
So I think we have the next group of panelists joining online. I see some faces popping in. So there is still some coffee if you want to grab some. We're going to switch over to the next panel. Yeah, that's what I said. We have a coffee break, and we'll get the next panel queued up. So give us 5-10 minutes, and then please come back to your seats. We're going to be blended again on the next panel. We have some folks here in person, and then we have others that are joining us online. I haven't seen the online come online yet. But if you can take your seats, we'll start in about 2 minutes. Okay, I'm going to turn this over to our moderator and welcome our online panel. So would Mr. Stephanopoulos Tyrus take over, please, for me? Thank you.
Thank you very much, everyone, and welcome back to the next session titled Rewarding, Compensating, or Rehabilitating Whistleblowers. We're having a very interesting panel that I'm going to be introducing as they speak. This includes Tom Devine, Legal Director from the Government Accountability Project, Chido Onuma from the African Center for Media and Information, Samantha Camilletti, who's a program officer at the Emergency Assistance Program, and Dr. Stelios Andreadakis, who's a reader in corporate law at the Brunel University in London. I have to say that this is not, of course, my program of expertise. I'm a labor economist, so I was thinking of how to introduce this panel. And despite being an economist, the first idea that I thought about was, what is the issue with rewarding only the financial aspects of whistleblowing? Can this cover all the different types of whistleblowing? And what types are the whistleblowers? Some of them don't need financial incentives, but might need support or might need rehabilitation after the whistleblowing has occurred. So I will leave the experts in the panel to lead this discussion, and then we can move with any further questions or comments as we go. So I will start by introducing Tom Devine, who's a renowned legal expert. He is the legal director of Government Accountability Project since 1979 and has helped above 7,000 whistleblowers around the world, and also to set up the legal systems, not only in the US, but also abroad, including the EU. So I will leave the floor to you, and thank you very much for being with us. You are on mute at the moment.
Thanks for inviting me. It's an honor to participate today. And I may have a little bit different perspective on the rewards program than some of the other panelists this morning. But I want to start out by giving credit to an initiative which has significantly increased the profile of whistleblowing, and say that probably the most significant positive from the rewards programs in the United States is that whistleblowers deserve the money. The remedies and anti-retaliation laws at best get people back to even financially, and that doesn't really compensate for all of the indirect effects on their lives and their future in their professions. So the traditional anti-retaliation remedies really are not adequate. And there's no question that people who are making such a significant contribution to society and who may be making a significant contribution to the organization where they formerly work or where they do work deserve the compensation. I also think that the rewards program deserves credit for getting a significant increase in evidence to the Securities and Exchange Commission, the Commodity Future Trading Corporation and Commission, and the Internal Revenue Service in the United States, the three agencies that have the most active reward programs. Those are all very positive aspects about the rewards programs that have happened in the United States. So why haven't they increased globally at a much more significant pace than they have? And why has there been objections to rewards programs? For example, the United Nations Commission Against Corruption chose not to include rewards programs in its mandate for global best practices in whistleblower protection last December. Well, there's a few reasons. The first is that the rewards programs have increased retaliation against whistleblowers. And really the first priority for our movement has to be making it safe to engage in freedom of speech, so that it's not an act of professional suicide to do the right thing and to contribute evidence that may be significant, not welcome, but significant evidence for the benefits of where you're working even, let alone for law enforcement. That's the goal of our movement, is to reduce retaliation. And the problem with rewards programs is they've increased paranoia and defensiveness by employers, so that when whistleblowers come in to share evidence that's completely independent of a rewards program or getting a bounty or anything else, they're viewed as suspects. Suspects who are liable to turn on the company and betray the organization in order to get a payoff. And that's the motivation then for preemptive strikes, for more retaliation against people who really were just trying to do the right thing. 96% of corporate whistleblowers don't break ranks. They're blowing the whistle internally within their organization out of what they believe is a defense of the organization. But with the rewards programs, their employers oftentimes are thinking, well, they're just doing that because they'll get a higher reward if they check in with us first, which was something that was demanded by industry, that people have to check in with their employer first in order to get the maximum reward. And that means the whistleblowers are identifying themselves as potential threats, and with highly defensive employers, that's led to an increase in retaliation. Not a huge increase, but 2 to 3% a year higher rates of retaliation against corporate whistleblowers than before the bounty programs. And that, frankly, involves tens of thousands of whistleblowers facing retaliation that our movement has been committed to preventing. The second problem that I have with reward programs is that they've given dishonest corporations and industries which are engaged in questionable practices an opportunity to basically to smear, to trash whistleblowers. Our movement has spent decades developing, trying to change the stereotype of whistleblowers from people who are kind of crazy or people who are betraying their colleagues, betraying their friends and people that they work with, kind of like, Benedict Arnold's in the United States, people who are traitors to their communities. We've spent decades changing that to people who are profiles in courage, who are risking their entire professional lives in order to defend their organization or the public against those who are cheating. And we've been successful, largely. In the United States, for example, the most recent surveys were that 86% wanted stronger rights for whistleblowers. They've become popular heroes in our media, in our culture. But with the rewards programs, companies are engaged in active public relations campaigns to say that these whistleblowers are like Judas. They're whispering in the government's ear in order to get paid off to betray their colleagues. And this has been particularly hit a particular chord, not just in the United States, but in Eastern European countries or other nations where there were dictatorships that did engage in those practices, offering people bribes to turn in their neighbors or their colleagues at work. And is threatening the public solidarity, which is every bit as important as official legal rights. Really, the third strike for me with bounty programs have been what a tiny token percentage of people actually receive the rewards. It's almost like winning the lottery. And I just have trouble being too enthusiastic about an initiative that actually helps very few whistleblowers and increases retaliation across the board and undercuts public solidarity for our movement. I say all of this with a significant degree of hesitation and regret because whistleblowers do deserve to get compensated a lot more than the anti-retaliation laws provide. And that leads me to two suggestions that I think are alternatives to rewards programs. One is public recognition in merit raises to whistleblowers, just normal, routine, positive reinforcement within the organizations where they work, such as Speak Out Awards. The chief executive officer honoring whistleblowers for their contribution to preventing liability or to stopping internal fraud against the organization. Visible public recognition, and then a raise, a well-deserved raise or a bonus from the organization where they work for making the contribution that they deserve that reinforcement for. The second is if it's going to be outside the organization where the whistleblowers work, there is an alternative model that provides compensation to whistleblowers who make a difference. Its roots were in Great Britain, where they called it qui tam, allowing people to sue in the name of the king. And the United States has found its best model in the False Claims Act, where whistleblowers aren't limited to making noise. They also can file lawsuits on behalf of the taxpayers to return fraud in government contracts. The False Claims Act is America's most effective anti-corruption law. Just for fraud in government contracts, last year alone, it received $2.7 billion in recoveries from whistleblower lawsuits. That's more than all of the bounty reward statutes combined in the United States. This is a model which is more effective than simply giving rewards to whistleblowers, because it enfranchises the whistleblower to team up with the government in the law enforcement action. And the whistleblowers have a lot more to contribute than just an initial drop of evidence. They should be partners in getting the most effective results. And that's what's happened in the False Claims Act. The False Claims Act also hasn't led to any backlash against whistleblowers because they're getting rewards, but they're fighting and winning the battle on behalf of the taxpayer to earn those rewards, not merely whispering in the government's ear. For me, kind of on balance, whistleblower rewards in the United States have been pushed much more by law firms that are finding the reward programs to be easy money. They get 40% of the recovery just for filing a complaint, basically, with the initial evidence. They don't have to go through the muss and fuss of winning a trial. And the rewards have been significant in getting more evidence. It's just that there's a better way to do it, in my experience.
Thank you very much for your analysis. Then I will just, because we have a couple more minutes, I would just like to ask you to give some more info on one of your points where you stress, which is public recognition. It seemed from what you said that this can act as some form of defense towards the whistleblowers. So what can this be done what more can be done from the state's perspective? Is there something, or is it something that is in the hands of the NGOs and the public to build this public recognition of the whistleblowers?
Well, I would think that any far-sighted chief executive officer at a corporation is not going to just want to have non-financial rewards, positive reinforcement, recognition, certificates, an internal matter within the corporation. I think that would be very, very good advertising for corporations to not only reward whistleblowers, but to publicize that they're rewarding whistleblowers. It's basically saying that we live the integrity of our advertising slogans. And not too many organizations can actually say that the reality within their environment is the same as what they'd like to take credit for. So I think it would be an excellent way for companies to promote themselves by promoting whistleblowers.
Okay, thank you very much for this. So we're moving on now to our second speaker, Chido Onuma. Chido Onuma is a coordinator for African Center for Media and Information Literacy. He's a Nigerian and Canadian journalist, media trainer, and human rights activist that has worked in several countries over the last year, over the last 30 years. So the floor is yours.
Thank you very much. I hope we can all hear me.
We can hear you, but we don't see you at the moment.
My video is on. I can see myself. I don't know what's... I can see myself.
Okay, perfect. We can see you now. Yeah.
Okay, so it's... All right. Well, thank you very much for this invitation, and thank you for putting together this conference. I just wanted to share. I've been listening to some of the ideas being put forward in terms of compensations for whistleblowers. I wanted to share the work we're doing in Nigeria and perhaps also learn some good practices from around the world, what's happening to whistleblowers. And I'm happy Tom is part of this. Tom has been quite supportive of the work we do in Nigeria in terms of trying to put it in proper perspective, as the saying goes. I'm the coordinator of the African Center for Media and Information Literacy. We run a whistleblowing project called Corruption Anonymous. And the aim basically is to amplify the importance of whistleblowing as an anti-corruption tool, but also lend support to whistleblowers who face retaliation and go through all kinds of problems, psychological, financial, legal, and so on. We started this project about 7 years ago with the kind support of the MacArthur Foundation. We've been able to work with about 10 whistleblowers in the last 6-7 years, and it keeps growing. Of course, one of the biggest concerns we have about whistleblowing in Nigeria is the issue of protection. About 7 years ago, in December, 8 years ago, this December, the federal government of Nigeria introduced a whistleblowing policy. So we don't have a whistleblowing law in Nigeria. What we have is a policy. The policy speaks to the importance of whistleblowing as an anti-corruption tool, but it also speaks to offering protection for whistleblowers. But even with that, we see that law enforcement agencies or citizens. So 5 years ago, we did a national survey asking Nigerians what their most important concern was in terms of blowing the whistle. And their response was the lack of a whistleblower law to offer protection for whistleblowers. And we've been pushing, since then, we've been pushing the campaign to have a whistleblowing law in Nigeria. So in terms of the topic for discussion today, which is the question of compensation for whistleblowers, there are a lot of not so positive aspect of the whistleblowing policy in Nigeria that addresses or seeks to address this issue. So what we have in terms of compensation in the whistleblowing policy in Nigeria, it says that if a citizen blows the whistle and it leads to recovery of fund for the government of Nigeria, that person is entitled to a certain percentage of the recovered amount. So let's say, and I'll use the Nigerian currency, the Naira, as example, or perhaps I could use the US dollar too. So let's say you blow the whistle and you recover $1 billion, for example, you are entitled to a certain percentage of that recovery. There are a lot of issues with this. So if you blow a whistle and the government doesn't recover money, you are not likely to get anything. And if you blow a whistle, the government says they already have the information about the whistle you blew. They are not likely to give you anything. If you blow the whistle, so the higher the money, the lower the percentage. So if you blow the whistle and the government recovers 1 billion naira or $1 billion, they are likely to give you the lower end of the scale, maybe 2%. So the payment is between 2% and 5%. The higher the recovery, the lower the percentage. So if you recover a lower amount, say $100,000 for the government, they can then pay you the upper end of the compensation, which is 5%. Of course, there is a lot wrong with this process. One is that it doesn't address issues with whistleblowers in the private sector. It speaks mostly to whistleblowers in the public sector. The second, of course, is the fact that it talks only about financial gains and contribution to the government of Nigeria. So if, for example, you blow a whistle that helps the government in reining in terrorists, which of course saves the country a lot of headache and saves the country a lot of financial loss, they are not likely to be compensated for that because there is no direct financial gains to the government. We could also take another example, like during the COVID period, there were a number of cases of whistleblowing that helped the government to tackle the malfeasance within the health sector. People hoarding drugs, people hoarding COVID-19 relief materials, people hoarding health materials that were needed to improve the conditions of citizens during COVID. But because there was no direct involvement of recovery of financial benefits to the government, all the whistleblowers, no whistleblower got anything for that. And we are saying, as civil society organizations, we are saying no, that whistleblowers should be entitled to compensation. Once people blow the whistle and it's identified that this is a genuine case and whether there is recovery or not, that the government should be able to compensate whistleblowers. So that's part of the campaign we are pushing for. There is a draft whistleblower bill in Nigeria. The argument from civil society organizations, including the organization I work for, is to expand this aspect of whistleblowing to ensure that whistleblowers get adequate compensation. Because, of course, they go through a lot of stress, trauma, and all that, whether in the process of blowing the whistle or after they blow the whistle. So if the case is settled, whether there is a direct recovery of money or not, whistleblowers are entitled to some compensation. Then quickly, the other aspect of this, of course, is also protection for whistleblowers. So there is a law in Nigeria which talks about something to do with identity of non-revelation of identity of witness protection. So we are saying that the idea of protecting whistleblowers should go beyond the concept of the concept of witness protection. So whistleblowers deserve compensation, one. They deserve protection of their identity when they blow the whistle, unless, of course, they decide to reveal their identity. If and when it becomes necessary, there are other things that can be done, including change of location, movement of family, change of identity, and so on. That should be part of the whole package of whistleblower protection. We believe that when we have all of this in place, that it will be more effective, it will be easier for whistleblowers to be in a good position to blow the whistle, will be excited. Many more people will willingly come out to blow the whistle. I think this kind of gives us a broad sense of where we are. As I said, part of why I'm happy to be part of this thing is also to learn from experiences from Europe and other places and what they've done or are doing with the whole concept of compensation for whistleblowers. Even as we struggle with the transition from having a whistleblower policy to a whistleblower law in Nigeria, and when the conversation opens up, one will then have a clearer idea of how to engage the process and make solid arguments, but also reference what is happening in other jurisdictions in terms of compensation and protection for whistleblowers. And I'm happy to take further questions or clarifications on this issue. Thank you very much.
Thank you, Dr. Onuma, for all the information you have provided with us. I will again just give a short question on this moment, given that I understood you were talking mostly about blowing the whistle on cases of corruption, etc. Do you think that the protection of identity for these people can work in cases where the people that they have to blow the whistle to are very close in the government to these people that they also need to give this information? How can this work in Nigeria, and do you see this problem right now?
Yeah, so it's a big problem, and part of the challenge we have is how to deal with this. Apart from the fact that there is no whistleblower law in Nigeria, which makes it difficult. So you can't even then you can't proceed to the courts, for example, in terms of providing protection for whistleblowers. There is no extant law for the legal system to fall back on and say, oh, this is what the law says in terms of whistleblower protection. But that's on one side. The other more important issue in addressing the question you raised is the protection of identity of whistleblowers. My country, and I hate to say this, but that's the reality, we face a serious problem of corruption in Nigeria. Not everybody is in tune with corruption in Nigeria. There are a lot of patriotic citizens who want to blow the whistle. So many of them are afraid that if they blow the whistle, either within their organization or within the larger state institutions, they will get into trouble for that. Or when they get into trouble, nobody is going to come to their aid. We are dealing with, at the level of my organization now, we are dealing with a number of whistleblowers that we have to raise funds. Many of them, they have withdrawn their salaries. Some of them have lost their jobs. Some have lost their homes. They've lost their spouses and their children and partners have left them. Some are, going through emotional and psychological stress. We have to raise funds for them. There are some people who don't care. One, they don't care about the money. They say they are doing this thing out of their own patriotic zeal. There are those who don't care about their identity. They are willing to make public what they want to blow the whistle on. They don't worry so much about their safety and consequences. But there are those who are also worried about their identity and so on. So the question is, for those who want to be protected, how do we go ahead and protect them? It's a big challenge here because, again, I go back to the question of corruption. These issues about whistleblowing protection, it's state agents. Many of them are corrupt institutions. So when you blow the whistle and then you report to an anti-corruption agency or a law enforcement agency, there is the worry that people within that agency can turn around and use the information you provide them to either make money or expose you. So they can, let's say there is a big government official in one of the ministries, and I blow the whistle against them and I report a case to one of the anti-corruption agencies, it's possible that people within the anti-corruption agencies would inform the public officer involved to say, oh, we've received a petition from one of your staff or somebody from your organization accusing you of this. And then the big public officer will then go back to the institution and begin to fish out the person who leaked that information or who provided that information. One of the ways, or one of the things we've tried to do is two things. The government agency that is responsible for whistleblowing has a secure website for people to put their information anonymously. At the level of my organization, we also have a system where people can come to us directly in our offices to complain, fill out some forms with their information, knowing full well that their identity will not be exposed. But they can't be too sure of the government website where they provide the information. So to answer your question directly, it's a big challenge. And we try to educate people to let them understand that there is a way you can report information anonymously without sacrificing your identity, without putting yourself into trouble and so on. It requires a lot of work on our part to continue to do the advocacy, inform people that unless you want to do this thing intentionally to expose yourself, you can also report anonymously, and that there are platforms that you can do the anonymous report so that you protect your own identity. I hope I'm able to answer your question.
Yes, thank you very much for this. We're going to continue the discussion after the panelists have finished, so we're moving to the next panelist, Samantha Camilletti, who will join us in person. She is a program officer at the Emergency Assistance Program at the Freedom House, which is providing short-term support to activists. Many times I help them survive attacks, continue their work, or even save their lives. So we'd like to hear more from you. Thank you.
Hi, good afternoon to everyone in the room, and hi to everyone who's watching on the live stream. As Dr. Tiros kindly already said, my name is Samantha Camilletti, and I'm a program officer at the Emergency Assistance Program at Freedom House. For those of you who don't know, Freedom House is a global human rights and democracy organization based in the United States. I will just note that Freedom House conducts many different types of activities, from advocacy to research to long-term programming in a variety of countries. But for the sake of time, I'll just focus my introduction on the Emergency Assistance Program before offering some reflections on this topic. The Emergency Assistance Program is a global program that provides short-term financial assistance to activists, civil society organizations, those working on LGBTIQ+ and religious issues, and non-traditional advocates, who we define as individuals that don't have a history of human rights work and are therefore largely excluded from a lot of other protection networks out there, but are at risk essentially because they spoke up about injustices that they have witnessed and are at risk because of it. Within the Non-Traditional Advocates Fund, one of the biggest groups we support is, of course, whistleblowers across a variety of sectors. And so finally, I think this explains my relevance to this panel as sort of a tie-in. In my opinion, we are almost a smaller, separate step that the whistleblower might interact with on the way to rehabilitation. You know, we're an emergency assistance program, so we can really only help an individual or group who has experienced attacks or otherwise, let's say, changes in their security landscape, including legal proceedings within the last 3 months of the application. We provide really whatever type of assistance this individual might need to mitigate or prevent further attacks, whether that's relocation support, safe house funding, humanitarian assistance, medical assistance, including psychosocial support, legal assistance, equipment replacement because of an attack or a digital security concern, and a broad range of other types of funding. So our basic goal with all of this is, of course, to save the individual, with a secondary objective of having them return to work in some capacity, which leads into our theory of change that if we can protect them and sort of stabilize their situation for a while, then they will go on to continue to be champions of change in their respective contexts. So again, this is a critically important step, but I think slightly separate from the rehabilitation that other, let's say, rest and respite programs, scholarship programs, and other long-term support programs might be able to provide. And so that was very quick, but thank you for your time, and I'm happy to answer any questions.
So, thank you very much for your presentation. I would like to understand a bit more in detail, because you say this is short term. So how short term are we talking about, and how easy it is for people to reach you? And also, you're talking about some kind of support that seems very wide, and that seems to me very hard to organize something like this. I assume this is in many different countries. So make it a bit more clear to us, what does your support do? In essence, what would have happened if you were not on that point, and why do you think this is very important in these cases? And the next step is, how can this be bridged later to the rehabilitation part after a short-term one?
Yeah, so let me try to answer all of those really good questions. So one is, we're helping, the assistance is from 3 to 6 months. So it really is short-term, and it really is about, let's say, stabilization of this person and situation. In terms of, you know, we've been doing this since 2007, and so I think naturally we've just built up many different types of networks, many different types of contacts, whether that's, of course, other civil society organizations, but also, you know, legal organizations, psychosocial support organizations, and a variety of other different groups. And so in a way, we're really networking with them to help provide this kind of holistic support that I was talking about. And remind me of your other question.
I think in the end, the question was, how can the bridge happen between your short-term support and the rehabilitation part?
Yeah, that's a great question. And I mean, to be honest, I think that's the sort of weakness that not just us, but really a lot of other emergency assistance programs sort of have to grapple with. I mean, the way that we put it in practice is it's really just based on the individual situation. So say, for instance, we provide 6 months of psychosocial support. Let's say this individual already has a therapist that they've identified that they trust and want to work with. We provide the funding for that. And then beyond that, we can connect them with other resources that we know about and kind of steer them in the right direction. I will say it definitely is individualized, and, you know, it's dependent on the different contexts. So it definitely is not always so neatly kind of packaged for this person to go on, but we really do try our best to give this person some sort of sustainable path to go on. Because we all know a lot of these people are really just coming with like no idea. they say, okay, I blew the whistle, I'm experiencing these intense threats, and I have no idea like what's going on, what do I do, and these kind of things. And so we really do try to be a bridge onto these long-term rehabilitation programs. I hope that helped answer.
Thank you very much.
Of networking or? Yeah, normally we protect our people, that we don't ever publicize really our people. And even if we do, it's anonymized. I mean, I will say one of the cases that we did is sort of this psychosocial networking. We do this a lot, actually, in a variety of different countries. And it is organizations that are more specialized in psychosocial support. And I'm really proud of us building up these networks, because I think, as we all know, that's really an enduring need with these people. So I hope that kind of answers your question. Yeah. Yeah.
Two questions. One, regarding the non-traditional whistleblowing, can you just be a little bit more, just to give us a couple of examples? And then it's a general question. When we're, let's say, advocating or just spreading the word about rehabilitation of whistleblower, are we in some ways discouraging whistleblowers? Because it's like giving them the message, it's a positive message, we are going to support you, but the negative is you're going to be needing rehabilitation. So something bad may happen and you will need support.
Yeah, so I'll answer your first question and then the other one. In terms of the whole reason we thought of the non-traditional name is, first of all, we're really trying to encompass a broad range of people. So yes, we definitely support whistleblowers. We also, in a lot of cases, are just working with people who have never interacted with the human rights space, which is where we're very much entrenched, but are standing up at key moments to talk about issues of anti-corruption, accountability, and similar concepts. And so that was, we were talking about naming a lot yesterday. I think that was really just our attempt to kind of encompass all of these people without the sort of negative connotation that I think, we were kind of interacting with yesterday. Whether that works or not is a whole other story. But in terms of the types of whistleblowing that, we receive, it really varies. We've been helping government officials, we've been helping corporate whistleblowers, people in intergovernmental organizations. I'll let you kind of figure that out. And so I think it really is broad. And of course, again, we always try to contextualize their plan based on their individual situation. So I hope that kind of helps with that question.
Yeah. And the second, regarding rehabilitation.
I think that's an interesting question, because we really do market ourselves as a safe space for these people. And we're not saying, as I said, we don't publish reports, really. Freedom House certainly does about their anti-corruption work and these kind of things. The emergency assistance program is really us saying, if you are experiencing these sort of threats, these, attacks, etc., you can come to us for assistance. So I think it's an interesting, I don't know if we are discouraging people in some way. I really hope we are encouraging that. If you're experiencing threats, please come to us because we can help you. So does that answer your question? Or?
Yeah, always, if you just call something rehabilitation, you're going to give a positive message, but some people may perceive it in a negative way, but yeah, you do always the best, but sometimes you have to keep that in consideration, how we're going to call a service in order to be able to give let's say, the positive message and to minimize the negative message.
Yeah, that's a really interesting point.
We have another question.
Hi, Samantha.
Hey.
And thank you for being here and supporting a cause. Short-term to long-term rehabilitation in 6 months. So we have a expiring day, let's put it this way. My
Yeah.
question is, first of all, do you let the whistleblowers know that, listen, this is a 6 month short term of support and you're on your own, or you can direct them towards other means of support, but have other options that, doesn't make them stressed of what to come next? And my second question is, how often, I'll put it this way, there are two types of whistleblowers. Ones that they haven't blown the whistle yet, they're thinking about it, so they're doing the homework, and then they say, what are my options? What's next?
Yeah.
And the second is obviously the ones that they've blew the whistle, they have retaliation, and they might come to you also for help. So do you cover both instances? Thanks.
Yeah, I'll answer your second question first because it's easier. But in short, yes. This is a somewhat new thing that we're trying in the emergency assistance program because by its very nature, emergency assistance is quite reactive versus proactive. But specifically with the Non-Traditional Advocates Fund, which I'm the program officer for, yeah, we certainly cover this sort of circumstance as well and say, okay, really building a protection plan before these people blow the whistle. And I think we've only had a few of these sort of instances so far. And actually, they've been more, let's say, witnesses before testifying rather than specifically blowing the whistle. But I think it's been really effective, and I think it's helped. And so I really do hope we continue, going down that sort of proactive support. The second question is, yeah, certainly. I mean, this is all part of our trauma-informed communication with these individuals and groups, is we say, really, we work with them to build some sort of 6-month plan, let's say. We can only provide this amount of assistance, this type of assistance, etc. What would help you most, essentially, right in this moment? And then, as I was mentioning earlier, we do our best to connect with other sort of organizations. Of course, it's very much dependent on the country and situation and these kind of things. But either that means we're directly connecting them or we provide some sort of list and resource guide that they can access and sort of feel empowered to go after themselves. So I hope that helped with your questions.
Yes, you did. So if I understand correctly, your service can be limited by countries?
Yeah, I mean, we are a global organization. We don't normally work in Western Europe just because of our mandate, but we work everywhere else. So it's, as I was saying, in terms of when we're building some sort of, let's say, off-ramp plan, let's say, it really depends on what are our connections in that country. Do we have very strong, partners that we feel good and comfortable about referring these people to? In countries where when we don't really have a presence, we can certainly try to point them in good directions, but, it really depends. So that's kind of what I meant there. But
Gotcha.
Does that help?
Yes.
Cool.
Thank you.
Okay, thank you very much, everyone. Thanks a lot.
What's that?
To Samantha Kamleti.
We have a question from my son, actually. Sorry.
Okay, we have one more question. And then we'll move on to our next speaker.
Okay, thank you.
And I think we should have some time for more questions in the end.
Okay. How do you plan on helping whistleblowers who are receiving threats?
How do we help? I mean, we're providing this sort of tailored assistance to individuals. Again, it's financial assistance, so it's not, let's say, this holistic plan necessarily, but within that, we do really try to, maximize the options that they have. And so if they're experiencing, whether it's digital security threats, we can help with, as I was saying, equipment replacement, digital security trainings, these sort of things. If they're experiencing physical attacks, we can work with them on relocating or medical assistance or really a broad range of things. And so, again, it really depends on the individual, but we're able to kind of, at least we're hoping anyway, to really broaden and holistically support these people. Does that answer your question?
Yeah, it does. Thank you.
Yeah, good question.
Thank you very much once again. We are now moving on to our last panelist, Dr. Stelios Andreadakis, who is a reader in corporate and financial law at the Brunel University in London and who has published on a variety of research topics, including the future of human rights in the EU. So, Dr. Sandriadakis, the floor is yours.
Thank you very, very much. Very interesting discussion. I would like to make some points that were not made earlier about the idea of rewards and financial rewards in particular. So the first point that I would like to make in this discussion that has been going on for quite a few years is that we keep talking about financial rewards only. And that's a point that Tom made as well in his presentation earlier, that there can be other types of rewards that we can use, and that's something that we forget. And most of the discussions that I have been participating or I'm listening monopolize on the idea of financial rewards in the United States and that model, which of course is working very, very well. And there is a good reason why the United States authorities are promoting it and they want to establish it in other countries. However, there can be other models. And we heard the second presentation from our good colleague Chido in Nigeria, and we saw that there is a policy that the system of rewards is very, very different. You know, for some people it doesn't make sense, but there are different models that we can use for rewarding whistleblowers, not only the financial element, and also not only the US model that is very, very specific and works in the financial market sector. The second point that I would like to make is that, again, we need to take a step back and approach financial rewards not as a system, but as a part of a comprehensive framework. I think it's mistaken, it's wrong to see it and talk about it in isolation, or whether we should or we should not have financial rewards as a country or as a region if we are talking about the European Union. It is a very interesting mechanism, but is working. If it will work as part of a broader framework and as part of policy, legislation, and regulation, exactly like it happens in the United States, although it is quite fragmented, in my opinion. And one example that I would like to give is a country that I'm working during the last years together, which is Chile in South America, together with the Financial Markets Authority, that has introduced the idea of financial rewards, basically copying and pasting the model of the United States with anonymity and with financial rewards for whistleblowers of the financial sector. But in this country, there are no anti-retaliation rules. There is not a comprehensive framework for whistleblower protection. So people are very unclear. They are puzzled about the system and they don't know how to utilize it. And then if we add that it's a very small market and there is a very small pool of people who are working in the financial sector, then everybody knows everyone. And it's very hard for someone to blow the whistle without the fear of retaliation and without having any protection from the law. It's very, very difficult, even with anonymity, to decide to utilize the idea of financial rewards. So it's a very good example of an idea that works well, but we cannot just copy and paste to another country, hoping that it will work in the same way that it works in other countries. We need to see the other elements that support it, because without a basis, it's not going to work. My third point has to do with something that I talked a bit about yesterday, about the cultural element. Because again, now with the European Union directive, the member states of the European Union had to make some decisions about how to implement the provisions of the directive. And one of the decisions that they had to make was about whether they should implement financial rewards or not. And we need to see and discuss whether financial rewards are in line with the culture of every country. I made the point yesterday about the countries from the Iron Curtain or the former socialistic countries, that the idea of whistleblowing is problematic, at least to the previous generation or to the older people. So, firstly, before we talk about financial rewards, we need to see what is the culture of the country regarding whistleblowing. And I think this is the first discussion before we say, let's pay them and how much we will pay them and how much percentage. Maybe we should start with emphasis on the training, to train people about whistleblowing, to explain to them who is a whistleblower and what they need to do. The media coverage, we need more success stories. We need more positive messages, not messages about people who have been suffering, retaliating, or people who are just snitch and traitors. The processes. And then once we establish that, we can talk about rewards. And I think Greece, our country, the country where we conference is now, is a good example. And in my opinion, maybe I'm wrong, and forgive me, but I don't think that we have a culture of blowing the whistle. Not yet. We don't have the idea. So I understand the decision of the parliament, of the government, not to utilize financial incentives and financial rewards yet. But I'm just wondering, what about other type of incentives? What other type of rewards until we have an environment that is open, where an environment where whistleblowing is acceptable, and the blowing the whistle is the rule, not the exception, like it is now. So it is very important to see how people think about and thinking about it, what they know and what is their precondition towards whistleblowing before we decide about the financial issue and the rewards and whether we should follow the US model or the Nigerian model or any other. And the last point that I would like to make, which I think summarizes the previous one, is whenever we are talking about financial payments to whistleblowers, I think we need to decide whether we are talking about rewards. In reality, are we talking actually about rewards or about compensation for the inconvenience and for the professional suicide, let's say, if I can use this phrase, that they are likely to suffer or they are going to suffer. Because this is also important for the design of any program of financial rewards, and also for how much money they should take, what percentage they should take. Again, I have seen that in many countries, including Chile, where the money that they are offering are very few, and it's not worth it because it's not actually a reward. Because if it is a reward, it doesn't serve its purpose. And if it's a compensation, it's not enough because these people will become pariahs. They will never get a job, like many stories that we have heard from whistleblowers who are unable to get a similar job, not only in the country, but anywhere around the world. So this will help a lot governments decide what they want to do and how they want to proceed with the idea of financial rewards. As rewards, to reward someone and acknowledge their value and their contribution to transparency and accountability, or it is a compensation because the law doesn't work or the culture is not open and we are not ready yet to accept that someone blows the whistle and the rule is to shoot the messenger rather than listen to the messenger. Thank you very much.
Thank you very much, Dorcos Andreadakis. So I will also give a short question here, and I will push a bit more on the Greek examples. On the Greek example, which is true, there's no culture of whistleblowing yet, and also it's not something you hear often, especially positive examples. What you do here, though, is slaps that have been growing over the last year, even from people close to power, towards reporters, for example. So what are the steps you would recommend for Greece to start building on until we reach to a complete system?
Very practical question. Thank you for that. I think the first step is to make people understand what it is. And that's something that I experience a lot when I'm going back to Greece, because I live and work in the UK, and I tell them about my research. And when I try to explain them what a whistleblower is, they immediately tell me, yeah, the snitches, the rats, and I get crazy because by definition it has a negative connotation. So no one wants to be a rat. No one wants to be a snitch. It's not something that you want to put on your as a label. So the first thing is the perception, and not to change the perception using propaganda. Explain what this mechanism is, because whether we like it or not, it is the law of the country now. So it is a model that works across the European Union. So that's the first point. And the role of the media is very, very important, because I haven't heard a lot of stories about the new legislation. And if I want to share an anecdotal information, story is that when the parliament approved the new legislation, I wrote a small article and I approached three big newspapers to publish it about the idea of whistleblowing in Greece. And it was rejected by all of them because it's not a priority, without any comment. Second step can be training in the companies, because again, it's a law of the country, and people who are not lawyers or who are not working in this area do not really know what it means, what it is, and what are the steps, what is the process. Like Aris said before, how they can do their homework before they decide whether they should blow the whistle or not. I think I can go on, but I think these are the first two steps if we want to talk about normal people who are working in companies, and while working and they're going to work and they are living their life, they come across something illegal and they feel the need to report it, either because it's the right thing to do, or because that's what the law says and they need to be law-abiding citizens.
Thank you very much for this further comments. So I would like to take some further questions from the audience.
Hi, Stelio. Nice to see you again. This is Ari. You and I, thank you for being here virtually. I know you were planning to come over, but you came across some issues with your visa. So you and I had a long discussion in Puerto Rico about this. Am I right? Last year we met in Puerto Rico and we did a panel together about the whistleblowing, my whistleblower story, and rehabilitating whistleblowers. Again, we debate the rewarding or compensating whistleblowers. So we made a lot of progress since then, both of us, I think. And it's quite interesting what you mentioned, because where do we start? We start from public awareness. I think it's key number one, that the public needs to know about not the whistleblower name as a tag, but about the whistleblower as a concept. What it stands for, what's the benefits, who benefits. So then we go to a step behind that, and that is education. We need to educate as early as possible, as my friend Vasily said earlier on. We need to educate our kids, how not to be afraid to identify corruption. They need to identify and report corruption or wrongdoing in our kids' eyes from an early stage. So we have education, we have public awareness. But still, something is missing. We have so many obstacles on a global level. We have different countries, different cultures, different names, different legislation. And that is going back to last year, where we need to find a global solution for a global problem, as my friend Georgina from the UK, Whistleblowers, had told me once. What do you think about this?
I completely agree with the idea of education, and it needs to start from younger ages. So I can see next to you, the younger generation is here, so at least he can help with spreading the word. But not in a way that we will all become activists, because I'm a lawyer, I'm not an activist, and I work in the UK, where the idea of financial rewards has been rejected, at least for the financial markets. So we need to explain to people in a simple way what that means and what are the benefits. Because I strongly believe that we don't have as a country the culture. And then we can see it at a regional level, the European Union, Europe, and then at a bigger level. By training, I'm a corporate lawyer and have seen that harmonization and unification of law is problematic even in areas like company law, where a company is roughly the same everywhere. So for whistleblowing, it's more difficult when we're talking about human rights or when we're talking about freedom of expression and concepts that can be interpreted differently even within the same region. So I wouldn't put my money on something more international yet until each country or each region clean up their mess or decide what they want to do, what is their policy and the strategy. But there is no harm in putting it in there to sow the seed and wait until the right circumstances, when the circumstances are right, to blossom. So that's why events like that are important, and exchange of ideas, even if we disagree with each other, or even if we agree that we are not ready yet, we are not there yet. So definitely we have discussed it many times, and I fully support your ideas and the work that you are doing. And I think me with my papers and my talks, and you with your institute and your presentations should continue, and that's how we can continue trying.
Thanks for that. Just remember that we need to hear it all sometimes, not by bureaucrats and lawyers, but also from whistleblowers themselves who've been there, done that, and had the T-shirt. Thank you so much for your time.
Thank you, Ari.
And here it's time to close this session, and so the floor is yours to introduce the next one.
Well, thank you. I know we're getting near the end of the day, and we should have Dr. Portas on the line. Is she here?
I am here, yes. Hello.
Wonderful. Thank you for being so patient with us today. I'm actually going to turn the mic over to Ari Donikas, my co-host for today, for our last session.
So, we exchanged a lot of ideas. We heard from whistleblowers from all over the world. We had experts in policies, policymakers, at least here in Greece, attorneys, and whistleblowers talking about their ordeals, talking about their problems, the thoughts, the challenges they're facing. Now, when I blew the whistle in 2004, and I did what was by the book called Internal Disclosure, I didn't know what I was doing. And that's Samantha goes to you. I didn't know what I was doing. I had no education in that department. I didn't know the word whistleblower existed in my vocabulary. I didn't know what it was. Never heard it before. So I was doing what any sensible human being will do the right thing. You identify wrongdoing at the place of work. In my case, it was as a volunteer in the police force. You see wrongdoing. In my case, was torture. And you're reporting to your commanding officer. So that's internal reporting. That didn't go well for me. Through my ordeal as a whistleblower, and in my search to find an effective way to save lives, to save whistleblowers, because we know corruption knows no borders. But protecting whistleblowers, it's limited by the ability of each country to implement its legislation in order to save those whistleblowers. I became an activist because I survived that ordeal. I survived physically and emotionally. So I became an activist, and I wanted to help other future whistleblowers not to go through what I've been through and not to have the end of dead whistleblowers as Babita Deokaran in South Africa and many others. I can mention Patricia Masale, a friend and a whistleblower who is trapped in a hostile environment in South Africa, who reported wrongdoing at the place of work, and she's been persecuted every day since then. So then I'm starting thinking, what made the difference between life and death? Why I'm still alive? I'm here. I have a lovely family. I live in a country with democratic values. I feel safe enough to express my freedom of expression or speech. What is the difference? And the difference is that I had a passport. I had a second passport so I can get away from a hostile country that me as a whistleblower was trapped. So I was fortunate to have a double citizenship, so I had two passports. I could get away safe. Babita Deokaran didn't have this option. Patricia didn't have this option. I can go on and on and on. So in my search of finding, in my simple mind, I mean, I'm not an expert, I'm not an attorney, to find a practical way to help save lives, I came up with the International Treaty for Whistleblowers concept. I'm going to read it for you, and it's going to be about a couple of minutes, and then I'm done with that. Whistleblowing is a vital tool in combating corruption and promoting transparency within both the public and private sectors. It allows individuals to expose misconduct, fraud, or illegal activities that will otherwise go unnoticed. The significance of whistleblowing cannot be understated, as it serves as a mechanism for accountability and safeguarding to the public interest. However, despite its crucial role in fighting corruption globally, there are still numerous challenges faced by national regulatory authorities in effectively addressing whistleblowing cases. To overcome these obstacles and ensure comprehensive protection for whistleblowers, there is a pressing need for the creation of international treaty or the Office of the Whistleblower, specifically dedicated to regulate those challenges. Regulatory authorities often face limitations and infrastructure challenges when handling whistleblowing cases. These challenges can include insufficient resources, limited legal frameworks, inadequate training programs, and cultural barriers that discourage reporting. Such limitations can impede the effective investigation and prosecution of corruption cases because they undermine the ability to collect evidence and protect witnesses adequately. Furthermore, without adequate safeguards in place for whistleblowers, anonymity and security during legal proceedings, potential reprisals from implicated parties can deter individuals from speaking up against corruption. To tackle these challenges on a global scale, the formation of an international regulator or independent regulated authority, referred to as the International Office of the Whistleblower, becomes imperative. This entity will focus exclusively on managing cross-border best practices, enforcing minimum standards, introducing policy enhancements and guidelines, and creating a public library of knowledge. Additionally, it will liaise with national offices on critical and urgent whistleblowing protection matters. This central organization could work alongside local regulatory authorities to seamlessly coordinate cross-border cases while offering support mechanisms for both whistleblowers and investigative bodies. In the past, there were many calls for international cooperation to combat corruption. We had IMF, I think, 1998, International Cooperation Against Corruption, and as well as Economic and Energy Food Crisis, WEFF 2023. An international regulator would serve as a knowledge hub where best practices in whistleblowing protection can be shared among countries. It could also facilitate capacity-building programs to enhance the capabilities of local regulatory authorities in handling whistleblower cases. By promoting cooperation and collaboration among nations, an international regulator will create a unified front against corruption. The creation of international treaty specifically focused on whistleblower protection offers several benefits in the fight against corruption. Firstly, it promotes consistency and standardization across different legal systems, ensuring that whistleblowers are protected regardless of their geographical location. Such a treaty will further provide a framework for issuing emergency visas to legitimate candidates who face serious concerns about retaliation. Additionally, proactive monitoring, reporting, and public exposure facilities on international level and regulated by international treaty can contribute to safeguarding the public interest. By encouraging reporting and providing robust protection for international whistleblowers, corrupt practices can be exposed promptly, leading to early detection and prevention of significant harm. The harmonization enables greater confidence for individuals considering blowing the whistle while minimizing jurisdictional challenges faced by regulatory authorities when dealing with cross-border cases. Local satellite offices will be established to represent the international office of the whistleblower in each country participating in this treaty. These offices will be responsible for handling serious cases, screening whistleblowers, providing initial support, and coordinating with local authorities. In situations where whistleblowers fear for their lives, their families' lives, or have faced serious retaliation, these local offices will have the authority to expedite visas for distressed whistleblowers, enabling their removal to a safer country. The combat against corruption through effective whistleblower protection carries significant economical implications. Reducing corrupt practices allow resources typically diverted to illicit activities to be relocated to essential projects like infrastructure development and social welfare programs. This relocation enhances public trust in governance institutions and promotes sustainable economic growth. A significant motivation for nations to implement the Office of the Whistleblower is the potential to reduce the Corruption Perception Index, CPI as we call it. This reduction can enhance the country's appeal to global investors, which is instrumental to promoting broader economic progress. I can talk quickly about the CPI 2023 highlights. That it was, it came up with Transparency Internationally. The global average remains stuck at 43, indicating a persistent corruption problem. Over two-thirds of countries score below 50, signaling serious corruption issues. 23 countries reached the lowest score ever this year. Weakening justice systems contribute to increased impunity for corruption, allowing to thrive. And both authoritarian and democratic leaders undermine justice, reducing accountability for public officials. Corrupt acts like bribery and abuse of power infiltrate courts and justice institutions globally. One of the main obstacles encountered by whistleblowers is residing in hostile countries where their actions are met with severe reprisals. This includes assassinations, threats to the physical safety and well-being, loss of employment or livelihood, and even legal prosecution, the slap suits. These obstacles make it exceptionally difficult for whistleblowers to come forward and disclose valuable information that can expose wrongdoing. The establishment of this expedited visa will create a standardized system through which legit whistleblowers under serious threat can seek refuge in countries committed to protect them from harm's way. By unifying efforts on an international scale, this treaty will send a clear message that whistleblower protection is not only crucial, but also universally recognized as an essential component of justice systems around the world. Under the proposal International Organization Treaty, embassies of participating countries will play a pivotal role in processing applications directly from the Office of the Whistleblower or in liaison with relative organizations who represent them and seeking temporary emergency relocation. These embassies could issue an expedited visa for individuals facing immediate danger due to the significant disclosure activity. Embassies will be responsible for assessing and evaluating the legitimacy of each application received based on established criteria outlined within the treaty, as well as the recommendation of the local office of the whistleblower. This process will ensure that emergency visas are granted to individuals who can demonstrate a genuine risk to the safety and well-being, as well as serve the interests of the cross-border countries they seek asylum from. By providing emergency visas through participating country embassies, this proposal seeks to create a unified approach towards safeguarding those who expose wrongdoing and corruption. The implementation of this proposal will not only enhance the security and well-being of whistleblowers, but also contribute significantly towards promoting accountability and ethical practice in both the public and private sector. And in conclusion, whistleblowing against corruption and wrongdoing serves as a vital tool in combating global corruption. Nevertheless, local regulatory bodies encounter several obstacles that impede efficient investigation and prosecution of misconduct cases. To comprehensively address these challenges and ensure adequate protection for whistleblowers on an international level, the establishment of an independent global regulatory organization is necessary. Member countries should recognize this organization as the authoritative body for guidance, expertise, policies, and addressing future whistleblowing challenges. By establishing an international regulator for whistleblower protection as part of this treaty framework, coordination between local authorities becomes more efficient, while support mechanisms are put into place to ensure the safety and security of those who report wrongdoing. The potential impact such a treaty could have on combating corruption is significant. It will promote consistency, standardization, and cooperation among nations while reducing corrupt practices and safeguarding public interest. Ultimately, the creation of an international treaty for whistleblowers will be a powerful tool in the fight against corruption worldwide. Thank you.
Thank you. Ari, isn't that online? Don't you have that? Where can people find that so they can read it and digest it a little bit more for themselves?
Thank you for reminding me. I'm actually quite tired, so sleep on mine. So on our Liberty of Speech website, it can be found under policies, and also Blueprint for Free Speech has published that study of mine. Thank you.
Thank you. So I'd like to also now introduce Dr. Luis Portas from the UNODC and from the UNCAC Coalition. We heard from Dr. Portas a little bit yesterday, and I'm hoping today, after hearing Ari's proposal for an expedited visa for whistleblowers, almost like this treaty for relocation, what can we do to get the UN to really endorse such an idea or incorporate such an idea into what we're doing with the UNCAC and with the whistleblower resolution?
Thank you very much. Thank you so much, dear Jackie, and good afternoon, everybody. It's very nice to be here again with you today. This is an amazing idea, actually. I was hearing music to my ears, if I may say, that we could have like a dedicated treaty on whistleblower protection, and maybe like a sort of international or central agency. Indeed, I'm part of what we call the guardian of the UNCAC. So my work is mainly around anti-corruption, but we know that whistleblower protection is way beyond that. It's not linked only to corruption, even if it's a very important matter for anti-corruption. I cannot tell that this is something that could happen, I hope. And all the work I'm doing so far on whistleblower protection is to maybe lead and discuss and work with the international community, all part of international community, to indeed maybe reach that decision and maybe have one day one single treaty and stop having like provision in various instruments. But what I can tell you now as my keynote speech is a bit of an overview. because even if we are not yet to a single convention and instrument, we do have a good progress on the international community, as I guess you all know. But I just want to maybe give you an overview of what we are doing at UNODC level, and how do we integrate and acknowledge the work of you and all the international community to keep providing technical assistance to countries. So I just want to say that the protection of whistleblowers and reporting persons is really repeatedly considered as one of the key areas to detect, investigate, and prosecute corruption. As you know, maybe in the UN Convention Against Corruption, we do have now 190 parties, and this is one of the areas where the states parties and the parties to the convention have identified the most gaps and technical assistance needs. If we look at the framework of the UNCAC implementation review mechanism, we can see that 70% of the people of the states parties who have been reviewed, they have received actually recommendations to consider strengthening the implementation of Article 33 of the Convention, and half of those countries also raised some technical assistance needs. So to date, the implementation of Article 33 continues to be among the 10 articles with the highest number of recommendations that we have. And I mean, I don't know, for those who are not maybe familiar with Article 33, it actually requires that state parties consider adopting measures to provide protection against unjustified treatments for persons who report offenses of the Convention in good faith and on reasonable grounds. The convention already makes clear distinction between what is a whistleblower, what is provided under Article 33, and what is provided under Article 32, which is related to witness, victim, and experts. So we have like a clear distinction between the various categories of reporting person, if I may say, but it's true that Article 33 is not really, I would say, up to date to what we are now in the definition and the protection of whistleblowers. And this is what we are saying, that UNCAC was among the first instruments to contain such of a provision of protecting reporting persons in the prevention and fight against corruption. But we emphasize the fact that the convention should not be singled out from other international instruments that treat this question. And we actually try always to provide a sort of kind of historic background of where it started and where we are at now, and putting the convention in the light of that, like it was 21 years ago almost, and we were not at the same level of definition and expertise regarding whistleblower protection. So we do have, as I was saying, like as a sort of overview of international instruments that we could highlight here starts with 2013 and the model law of American states, which refers to whistleblower and provide for the first time a sort of model law, even if it's not the most followed one or the most updated one. We see already some efforts going there already since 2013. In 2019, as we all know, we had like a big jump into having like really whistleblower, the term whistleblower and the definition on the top of the international community. First of all, we had the G20 high-level principles for the effective protection of whistleblowers that were adopted under the presidency of Japan. And 2019 is also the year of the adoption of the European Union Directive on the protection of persons who report breaches of union law. And that provide a detailed framework for the protection of whistleblowers and requested all the EU member states to adopt or revise their law in line with that. And I think to date is still kind of the state of the art in terms of regional instruments. But it's not the only one. Again, like we also had in 2021, the ISO 37002, and OECD also adopted new recommendations. They don't use really the term whistleblower, but they clearly provide the recommendation to afford protection to the broadest possible range of reporting persons in the work-relating context. And 2023, for those who were in Atlanta, and I recognize few familiar faces, so I guess that will be familiar to you. We had the Conference of States Party to the UN Convention Against Corruption, and which adopted the resolution 10/8 that recognizes whistleblowers as persons who report corruption in the context of their professional activity and work-related environments. So again, while Article 33 does not use the term whistleblower, it's still sort of the international basis for the only reason that it is included within the UN Convention Against Corruption, which is the most legally binding, almost universal instrument against corruption. So we use this like this UNCAC, which is like this how do I say opportunity of UNCAC to like bring whistleblower on top of the table and provide technical assistance to countries. And the resolution 10/8 is very important for that because it recognizes that Article 33 is not alone. It's not like UNCAC and the rest. Like Article 33 needs to be read in light of everything that the international community, the international like also conferences like we have today are doing, and what, as we discuss and always discuss about better defining whistleblowers, like this should be entering into consideration, and we cannot anymore consider Article 33 as fully in compliance if a country doesn't have something for whistleblowers. So this is really the work that we are trying to do. And we indeed, under this framework, provide an increasing and ever specific number of technical assistance because we do see that states parties to the convention do develop new whistleblower protection frameworks. They revise some old ones, and more they have advanced in that work, and more their request for technical assistance is very specific. So this forces us as well to always make our expertise, more developed and more specific, and be able to provide them with like really tailor-made technical assistance. We also see, for example, that the concept of whistleblowers, because it gets better defined and becomes predominant on the international scene, sometimes is not understood the same way, or it's not always a clear understanding, which means that there is a lack of harmony in the definition. There is a lack of understanding. Some people may think they are whistleblower where they are not, or the other way around. That we heard people saying, I didn't know I was a whistleblower. So we know that this can be difficult for them, like it can increase their risk, their vulnerability, the whistleblowers. It can also make the distinguish between whistleblowers and other categories of reporting person more difficult. And today, when we provide technical assistance to countries, we still have a lot of discussion and a lot of convincing discussion to convince them that there is a difference between whistleblowers and witnesses, but whistleblowers still need protection, physical protection, and the same kind of measure that witness usually benefit. But they are not witnesses, or if they are becoming witnesses, they are also whistleblowers. So this is like a long discussion and convincing moments that we have with a lot of countries in this regards. So yes, there is a great need for clarification of this concept. There is a great need for a better understanding of the notion of whistleblowers, the difference between whistleblowers and other categories of reporting persons. UNODC, now mandated by the resolution 10/8, will and continue and expand its technical assistance provision, keep supporting countries in getting robust, safe, more inclusive whistleblower reporting and protection system. We also work a lot in raising awareness on the impact of gender in the whistleblower protection and what can be done to have like whistleblower protection mechanism more gender sensitive. This is a big chunk also of our work. But I do hope, like you, that the resolution 10/8 is only the beginning. It's a bit small. It's just to specify an article of the convention. So I do hope that the resolution is a beginning. We will be able to go more far. And I do hope that during my time still, and maybe I will be part of the adventure of hopefully maybe one day developing an international instrument dedicated to the protection of whistleblowers. I'm all with you on that. I can't promise that it's going to be under UNODC. Well, I hope so. But no matter who is taking this challenge, I would really be happy to support it. And thank you very much for inviting me today.
Thank you, Dr. Portas. I think we have some work to do together. We have another year and a half for the next UNCAC, so maybe we can come up with some ideas. We'll have another meeting just about that. So,
let's hope, yes.
Yes,
thank
please.
you so much.
Samantha Kamaladi.
Hi again, everyone. Ari, also, like Dr. Portas, I'm so inspired, and I really hope that this treaty does gain popularity and we can get something going, especially coming from the NGO space. I think the idea of having some sort of central international regulatory body that's investigating and doing this kind of work is really astounding, and I'm just hoping that it goes far. Just for those of you who might have joined the live stream recently, my name is Samantha Kamalati. I'm from Freedom House's Emergency Assistance Program. Our Emergency Assistance Program started in 2007, and throughout all of that time, we know and we've seen how important it is to protect and sustain these individuals who are often putting their lives on the line because of their anti-corruption work. And so I'll keep my remarks brief, but I have just two main thoughts on how we can fight corruption by protecting those who are on the front lines of this fight and use this kind of pre-existing spaces we have in the NGO space to do that. Of course, since I'm coming from the protection sphere, I am approaching my thoughts from that angle. First, I think it's important for emergency assistance programs to broaden their criteria of who they consider a human rights defender. There are so many different types of assistance programs out there for journalists, writers, artists, women, and those working on LGBTIQ+ issues, lawyers, people from indigenous communities. And yet, there's still a whole range of people out there that are falling through the cracks of these various criteria, to include whistleblowers and those working on anti-corruption work. We've only recently done this ourselves through the Non-Traditional Advocates Fund that was started at the end of 2022. But through our fund, we've expanded our criteria to include witnesses, survivors of gender-based violence who are demanding accountability, first-time protesters, family members of dead or missing activists that are just trying to gain some answers and get government accountability, political activists and elected officials, and a whole host of otherwise ordinary people who are standing up at key moments to advocate for more transparency and more accountability in their respective contexts. I think this is important to consider because these types of profiles are not considered the standard human rights defender. And I think to truly marry the human rights and anti-corruption space, which there's a lot of talk and conversation about, more can be done to support these individuals. Secondly, and this has long been a problem we've identified in the protection space, so I'm not saying anything revolutionary here, but there should be more medium and long-term options to support and rehabilitate these anti-corruption activists, and better, stronger connections between the short-term assistance that we provide, for example, and what other programs might provide, and we were discussing that on the last panel as well. This includes opportunities for rest and respite programs, scholarship opportunities, and other safe spaces that can be provided to re-energize and provide opportunities for these whistleblowers and other anti-corruption advocates to share their often hard-won experiences and expertise with others. These opportunities are far and few between for activists, but they become even harder for whistleblowers and others in this non-traditional space to access. And then finally, I think it's just important we have conferences like these to meet and share ideas, but also just to make sure we're not working in isolation. I think that's truly how we're going to be able to combat corruption on any sort of scale. And so thank you so much for this time and space, and I'm here for any comments or questions.
Thank you. If we do have a couple of minutes, if we wanted to take some questions. Dr. Portis, I think you might still be on the line.
Yes, I need to go in 5 minutes, but I'm happy to answer some of the questions if there are some in the room.
Ari, did you want to? You look like you've got the mic. Or go up to the podium.
Hi. Yes, I have a question on the environmental social governments by the EU, the EGC. I think the ESG 16, that's a sustainable development, I think, program. And
the SDGs of the UN.
Yeah, and they talk about peace, justice, and hold on a second. Oh yeah, they talk about corruption, bribery, as part of the goal. So I think the whistleblower concept fits as a tool within the ESG 16. Any comments on that? Thank you.
She's coming.
Yes, sorry, I was wondering if I had to speak directly. Yes, I mean, of course, the United Nations Convention Against Corruption is one of the instruments that is made to fulfill the SDG 16.5, the one on corruption and bribery. Obviously, all the work that my office is doing is always always integrated in fulfilling this SDG. And because UNODC, my office is the guardian of the convention, all the work that we are doing on whistleblower protection is fully integrated as well in the global work on anti-corruption. This is considered as like part of it and part of the fulfillment of SDG 16. So we always, let's say, check our work against SDG 16 and report it for being recorded as one at the way to fulfill our obligations.
Thank you. And I do want to point out, for those of you who can see me, I am wearing the SDG goal pin that I got when we were at the UN this March for the Status on Women meeting. So there is I think a constant around the clock activities in relation to implementing these goals that we would love to be more a part of. Any other questions or comments for Dr. Portis? I know she said she had to leave. I don't know if she can hand you without the microphone.
Are you familiar with Article 33 of the UN Convention on Corruption regarding the criteria for whistleblower organizations.
He's asking about Article 33 of the Whistleblower Convention.
Corruption
Corruption.
Convention.
Yes, thank you very much. Indeed, the Article 33 of the Convention requires states party to the Convention to take the necessary measures to provide protection against unjustified treatments to any person who reports offenses of the Convention, which means corruption, in good faith and on reasonable grounds. So this is the basis. This is very broad, but also sort of like eternal, if I may, like that's not going to expire anytime soon. But our work in UNODC is just to explain countries that to fully be in compliance with this article, to fully implement this article, and for the protection that is provided by the Convention to be really effective. You cannot just copy and paste that article into, like, for example, a broader anti-corruption law or a broader reporting protection law. Of course, many countries, between the adoption of the Convention and, let's say, the past 5 years, they thought that implementing Article 33 was that. But then they realized as well that when you try to actually implement those laws that are not specific enough, they do not succeed in having like really robust and effective protective mechanism. They do not have enough tools provided by the law to adapt to the specific situation of the various categories of reporting persons. So it started by the US originally to have this like focus on insiders and develop the concept of whistleblowers. But it's just, we are discussing with countries that if you want to fully implement Article 33, you need to have different frameworks, different mechanisms for the various reporting persons. Of course, I mean, normally I have 2 days to explain that, so during my speech today, I didn't go that far, but like there are like some specific elements. You have like a wide range of categories of reporting persons, and all of them need to have a dedicated measures and framework. And when we talk about whistleblowers, then we talk about a specific category of reporting person that needs also to have a specific kind of protection. So that's what we say about Article 33. It's good, but it's very generic, and it needs to be read in the light of everything that we are doing, including now, like everything that the international community is doing, discussing, advancing what we call the global standards. All of this should be like integrated into the implementation of Article 33.
Thank you.
Thank you, Dr. Portas. I think we're going to transition to our closing remarks. So thank you. I know you have a meeting.
Thank you very much. Thank you for everybody. Goodbye.
Goodbye. So as we close this conference, Ari was going to provide some closing remarks. I believe we have Dr. Anna Damasco on the line as well from CAMS. Anna, are you here? We just a few minutes to summarize what's been going on in the virtual world.
To Aris, and I will go next. Thank you very much. Hi, is Aris going first? I cannot hear you.
He would like you to go first.
Okay, so thank you very much. We're coming to closure of two very full and very fruitful days. Personally, having been engaged with this topic, with this fight for the protection of whistleblowers for the past 11 years, I couldn't be more grateful to Aris, and I couldn't be more grateful to all the speakers, all the participants who have posed their questions and helped provide light to this topic. What I have to stress and give as a message in conclusion of this conference is first and foremost, I will take it from the other side, the interest of those. Usually we talk about the protection of whistleblowers, why it is important for whistleblowers to be protected, etc. But I will take it from the other bank of the river, taking into consideration that a whistleblower is meant within a working environment. What is the interest of the public and the private sector in protecting whistleblowers? It's actually protecting their own interests, their own survival, their own reputation. I believe that should be first and foremost organizations of the public and private sector that they should wish to strengthen whistleblowing protection instead of silencing whistleblowers, in the sense that, first of all, for reputational reasons, I believe they wouldn't want to see their case on the news for the first time before they have become aware in-house of the situation. For some corporations, this might mean, that their stock price goes very low. It might mean that they will close down, etc., due to the reputational consequences of all that. But it should also, first and foremost, be a primary concern, a genuine wish to have a corporate culture of such quality that they aim to boost, to encourage, and to protect whistleblowers in-house for the very selfish reasons of protecting their interests and protecting their survival. Usually, when we're trying, as in my capacity, for example, the past as compliance officer, etc., trying to convince, high management in that whistleblowers should be protected, and facing resistance from management, why do we need more provisions? We have audit, we have external sources like justice or external audits, etc. No, it should be first and foremost the interest of the corporation, be it in the private and public sector, to protect whistleblowers holistically, their career, their life, their family, their well-being. And this is also a message that needs to be taken out of this conference today. We always take the position on the side that, of course, we do very well of the whistleblowers, because they're the ones who suffer. They're the heroes in those cases, the heroes and the victims at the same time. But we should also pass a strong message of corporate governance. Corporate governance for the very selfish reasons of the continuation of the existence of organizations. And this is a message that I would like to pass on my part. I'm sure Aris will focus more on the whistleblowers having experienced what he experienced himself in the past. But let's also pass a strong message to the other side of this equation. Thank you so much.
Thank you, Anna. Ari?
Thank you, dear Anna. Nice to see you. I know you want to be here physically, but there were some complications. We appreciate your input. So we came to the end of this, our first international conference as Liberty of Speech. I would like to thank the panelists, both virtual and physically present, for the honor to come and speak to our conference here in Greece, and for the valuable inputs. Let's not forget the sponsors. I mean, it won't be possible without them. And a special thank to our co-hosting, Whistleblowers of America, who they honor us by coming all the way from the States to share with us their knowledge, their valuable knowledge. Especially, we would like to thank Jackie Garrick and Joe for their input. Now, we had, as panelists, journalists, attorneys, judges, social workers, IT experts. We had whistleblowers. We had families of assassinated whistleblowers. And we also had policymakers. But what did we learn from all this? Well, there are baby steps taken to protect whistleblowers randomly around the world, baby steps. The laws are written, but we have a hard time implementing them to practically protect whistleblowers. So we need effective protection. Effective protection before, during, and after a public disclosure. And we need rehabilitation. A whistleblower, he doesn't need to become a millionaire with a fat rewards, millions worth of rewarding system. He needs to be rehabilitated. He needs to be part of the society again because he's isolated, he's blacklisted, he cannot get a job. Perhaps his family is broken down. So it's essential that we need to understand. But witness of public interest, all the whistleblowers, need rehabilitation. And they need to be rehabilitated back to society. It's very important. That's why we have suicide attempts, but I think you'll talk more about it. So that's why we require a unified policy and perhaps a global policy that will eventually become unified into the cause of protecting whistleblowers. Thank you.
So I always like it when I get to have the last word. But I think as I reflect on the last 2 days, it's not about this conference coming to an end. I see these conferences and these meetings when we get whistleblowers together and the journalists and the lawyers, and we have this meeting of the minds. It's what do we do now? So we have this expression in Hebrew, it is written, when is it sealed? And there's a time between when things are written and when they are sealed. So we have policies, we've had publications, we have research. But I think what we do with it between these meetings is what's important. So my call to action is to take one lesson, just one. Take one lesson from this conference to the next meeting and to the next meeting. Implement one idea. Make one change. And I think when we make one, we win. So I look forward to having anybody who wants to connect with me come to DC. We're having our September meeting, and let's continue the process, let's continue the journey, and let's not just learn lessons, but implement better plans. Thank you. Safe travels. Enjoy this. The live stream will be or was recorded, and we will have it on the Whistleblowers of America YouTube channel So any piece that you missed or want to rewatch or want to watch for the first time, that's a one thing you can do as well.